Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. At this time, we have our citizens forum. This is where anyone from the audience can come up and speak on any topic that is not on today's agenda. If you would please come forward to the podium and just give us your name and address. And you can speak on anything. Anyone? If not, we will move on to awards and proclamations.
Item 4.1, presentation of plaques of appreciation to outgoing employee council members. Will Rita Stevenson, Cindy Beneke, Trapper Butennock, Tommy Highsmith, and Dennis Arnold please step forward.
And at this time, I would like Natalie Fisher to come up and explain the employee council for those that don't know.
Thank you, Mayor and Commissioners. Our Employee Council is a group of advisory employees made up of both supervisory and non-supervisory individuals nominated by peers and then appointed by Human Resources and the City Manager. They do a lot of advising as far as policy formulation, anything that affects employees, any concerns, and then any issues that we're dealing with. They work very hard to make sure the word is out and then that we have insight as to what is going on in our organization.
Is there any criteria as to how long they have to be a city employee?
There is not. Again, they are nominated by peers out of their departments. And they do serve a 2-year commitment.
Okay. Thank you, Ms. Fisher. So, on behalf of the city and appreciation for service rendered to the city of Salina, I'd like to present this plaque to Mr. Dennis Arnold. Thank you very much. I'd like to present this plaque to Cindy Beneke. Thank you. And this plaque to Trapper Butennock. Did pretty good, thank you. Did any of you want to say anything or make any comments? That usually gets them, so no, it wasn't recommended, but thank you very much. Thank you. They had 15 seconds of fame and they didn't want to say anything. We will move on to public hearings and items scheduled for a certain time.
Item 5.1, public hearing and report on petition number 4321 requesting closure and vacation of Cypress Drive from Willow Drive on the west to Comanche Avenue on the east and the replat of Edgemere Addition. Sub item 5.1A, first reading ordinance number 09-10525.
At this time, I'd like to open the public hearing. Mr. Andrew.
Thank you, Mayor and Commissioners. This is kind of a multi-layered application, so with your indulgence, I was going to break it down into 5 pieces here. One is the background and history of this area over time and how it got to this point. Focus on this west section of Cypress Drive from Birch over to Willow. Talk a little bit about the Birch Drive extension. Then the Cypress Drive east portion towards along the park and over towards existing Hickory Hut restaurant. And then the 5th aspect, which Mr. Schrag will amplify on, is a possible housing project in this area that also involves property access by Birch Drive. So I guess, Dustin, if you could start, this is the 1958 aerial photo. And what we tried to indicate in our report historically was the Edgemere Addition was a 100% residential subdivision, and in 1958 Crawford was a 2-lane street, and it was predominantly residential. There was no Interstate 135, and most of the frontage on Crawford was devoted to housing. This layout here is, these houses were oriented, they faced Cypress Drive, and then there was a tree line along the back on Crawford. And almost every lot in this subdivision, as it was laid out, was 60 feet by 110 feet. And that would be considered small, even by residential lot standards. It's a little more challenging when you have 60 by 110 foot lots and you're trying to do some commercial development on it. So during the peak of the use of the air base, there was a great need for housing, and this area was identified as a housing subdivision area. And so a plat was done, streets, water, and sewer lines were done, and it stayed pretty well unchanged. You see the 1973 photo there. There were homes constructed on every lot, and then in 1965, following the closure of the base, there were mass foreclosures in this area, and a lot of property sat vacant. Some houses were cleared, property changed hands, and in 1966, the city bought 18 foreclosed on houses in the north half of Block 4. And Dustin, if you could maybe go to the pedestrian easement slide, number 3. I have to boost that up a little bit, but what was referred to is the center block there. This block is Block 4, and at one time that had houses on every single lot. And then in 1966, the city bought this area, and all the houses were cleared, and that was purchased for park purposes. And then to the south of that, at a later time, 21 additional houses and lots that you see laid out here were purchased. So if you could go back to the 73 aerial photo, Dustin. 1973, a lot of the houses, these houses had been cleared on the park, but you can see houses here and houses all through here. And then in 1974, Roberta Kaufman, who owned the lots even then, filed a petition to vacate Cypress Drive and to rezone lots along Crawford, and also these two lots here to commercial. And there was discussion at that time about direct access from Crawford to the park. There was a land swap discussed, and it's not really clear what happened, but these lots ended up getting rezoned to commercial on the assumption that this street was going to get vacated and this was all going to be packaged together, and it didn't happen, which left you with commercial lots on the north and south bisected by a street. And I think if you go to the 83 one, Dustin, you can see these are still houses, and then this is the convenience store gas station, which was originally just an office building, and that was the very first commercial development done, and that was done after 2 rezonings. And then in 1987, there was a house converted to the original Hickory Hut Drive-In and a restaurant built just to the east of that. And so what you have before you is a request from Roberta Kaufman. I guess we can go, Dustin, to the current aerial photo. And the original idea for the petition was to go from here all the way over to Comanche. And there was some thought that the Blakes, who owned Hickory Hut, they had mixed feelings about it, and there was some thought that they might join in the petition. They decided not to join in the petition, but they didn't oppose it when it was first filed. But as they thought about it, they have since submitted a letter saying that they are opposed to that section being vacated, and as they are an abutting owner, that cannot be forced on them. So the amended request is to vacate this portion here, which would create one large lot there and a deeper lot here for potential redevelopment. So if you could go to number 8, Dustin, the grocery site plan. This, it's difficult to see because it's so enlarged, but this was a plan that actually could be built today, and that was to shoehorn in a little grocery store. This is Willow, this is Cypress, and this is Birch. And these are the houses here. And so under this plan, this commercial building would be 10 feet from this property line. And so what Ms. Kaufman would like to do is to eliminate Cypress and piece those two lots together into one development site west of that site. And Dustin, if you go to number 6. This is just an example of how it could be redeveloped. This is Crawford. This would be Birch extended. This is Willow. This is where Cypress runs today, and you would merge that all into one development lot, and that would all be to the west of Birch Drive. So that addresses the piece of Cypress to the west of Birch Drive. And then Dustin, if you could go back to the aerial photo. The second part of the equation is if something could be done to eliminate some of these driveways here and get side street access here so that you could extend sidewalks, get landscaping things here, and have a better orientation with the side street. Birch could be extended. The added benefit of that is that it provides a direct both street and sidewalk access from Crawford to the park. Over time, there had been comments from the motels on West Crawford about guests staying there and never knowing that a park was nearby because you can't really see it or get to it very directly. So the idea for extending Birch was to get direct access to the park and also to eliminate driveways and get side street access for the commercial lots. And then on the east, where you have Cypress Drive east, the original plan was to go over here to Comanche. This is the west line of Hickory Hut. The options would be to take this and vacate that and allow this lot to be deepened for redevelopment, or this could be left out of the equation and left just as it is. But if it were closed, then you'd have some sort of barricade and perhaps a hammerhead or something else here. This would come out in the future, and this would come out as redevelopment occurred. And so those are really the three main segments. You've got Cypress Drive West, Cypress Drive East, and the Birch extension. There was an original public hearing before the Planning Commission on November 17th, and then there was another hearing after it was referred back by you, where we sent notice to 163 property owners on Willow and Birch Drive, as far south as you could possibly go, just so they would all be aware of the application and the public hearing. And so there were a number of comments made, some that are reflected in the minutes, some that were forwarded to staff. There's also correspondence there from Hickory Hut, and there was a petition that was circulated by Mr. Casper in the neighborhood to get a sense of how people felt. There seemed to be discussion both about the Birch extension and the Cypress closure, but just a couple comments or points. This section here has water, sewer, and storm sewer lines, which means you could build driveways or circulation over it, but not a building. And so you can deepen the lots, you just can't put a building there, and there would be a need to retain utility easement to protect those easement locations. We showed you the illustration about buffers. If you visualize a commercial building sitting right here as opposed to a commercial building that would have to be no farther south than this, a redevelopment plan would probably result in a much bigger buffer space between development and this lot line than if these were freestanding lots. So you would actually have a better buffer if you had a redevelopment site than the two standalone sites that are there today. There was also concern expressed about access from Willow Drive to the park if Cypress were eliminated. Planning Commission tried to address that by requiring that at this point along here, which would be a landscape buffer, that there be a pedestrian easement provided right here with the ability to put a pathway in there. And then, Dustin, if you could go to slide 3 again, the pedestrian easements. These right here, there's one here, there's some farther south, but this is a pedestrian easement right here. This is Willow, this is Birch. This is an easement to the city of Salina to construct a path or sidewalk mid-block and the reason for that is that these blocks were so long and not broken up by streets that easements were provided right here so that you could build a sidewalk or path in the mid-block area to get people back and forth from Willow to Birch and to the park site. So it does not address vehicular access, but it does address pedestrian access. There was also concern about additional traffic on Birch Drive, and I don't think this drawing goes all the way through, but Birch Drive terminates at the south end by running into Hemlock, which is also a short segment street. This is Hemlock right here. Birch comes down and tees into Hemlock right here. So Birch is not a through street. The through street for this subdivision is Cherokee, which goes from Crawford through to Republic and Sunset School. I guess the other item we'd point out is within the last 10 years, an extension from Crawford to Faith Drive for Mound View was built, and there have been no complaints about traffic volumes or speeds as a result of that connection to Crawford. And then this would relate to the east segment there as it was conveyed to staff. The Hickory Hut objection has to do with the loss of parking, on-street parking behind their restaurant, as well as the concept that the owners feel like this street provides a buffer between the park and their restaurant. And to a degree, the fact that there are customers and employees that park on Cypress just reinforces how those 110-foot lots are really too shallow to accommodate parking and circulation and landscaping and all the things that you'd have with commercial development. And then there was the question raised about cul-de-sacs. And it is correct that if you plat a subdivision and create a new dead-end street, that all dead-end streets have to terminate in a cul-de-sac turnaround, or in some cases a hammerhead has been allowed. However, we do have a number of very short segment streets that are less than 250 feet in length that simply have a no outlet sign and terminate without a turnaround. So that would be a judgment decision for you, but that's referring to right here. If this street was left open and terminated here, the options would be a cul-de-sac, a hammerhead, or simply having some form of barricade and an indication that there's no outlet or that's a dead-end segment street. And so the state statutes require that you as a commission find that no private rights will be injured or endangered by the proposed street closure, and that the general public will suffer no loss or inconvenience if Cypress is closed or vacated. And there's no business or home or anything that has its sole access from Cypress. So you're not taking away anybody's sole means of access, so then it becomes a a judgment call as to whether that would be a loss or inconvenience to lose that street. The Planning Commission conducted a second public hearing on this on January 5th. You have the minutes of that attached. There were several property owners in the area who spoke. They talked about traffic and vehicle speeds on Birch, and concerned both about the loss of Cypress and the extension of Birch. There was also comments there from Mr. Mays representing the Kaufman family, and the Planning Commission voted 6-2 to recommend the closure and vacation of Cypress from Willow over to this line. So their recommendation was to close and vacate this portion here and leave this remaining. And then they had 6 conditions that they recommended relating to the filing of plans and the designing of Birch Drive, the paying of the cost of Birch Drive, the cost of pavement removal, maintaining a utility easement, making sure that there's a minimum 15-foot buffer at the south and a place for a walking path. If this street were built new, there would be sidewalks on both sides, but they were concerned at the Planning Commission that there are no sidewalks on Birch, and they thought the city should look at building sidewalks on one or both sides of Birch so that you could have more of a connecting link to the park. I did want to point out about the way the Planning Commission recommendation was structured, that this is only first reading or consideration of a vacation ordinance. If this were approved, then the ball would be in the petitioner's court to address all these conditions and items, so nothing would happen to the street in the meantime until all these things were addressed. And if those conditions were all met, then that could proceed to a second reading and actual physical changes to the street. But if this were approved and there were no actions taken by the Kaufman family to make that happen, then the result would be that the street would remain just as it is. As I noted, Dustin, if you could go back to the pedestrian easement portion. How do you want to handle that, Mike? Do you want to discuss the housing? We don't want to blend the two together, but I'll let you discuss the housing proposal and how it fits here. And Dustin, if you could go to that pedestrian easement slide.
Mr. Andrew described the traffic flow and the street segments in the area, and as he said, we don't necessarily want to mix the two issues, but did want to recognize the fact that one of the concerns raised by the neighborhood, or some of those that opposed the suggestion of Cypress Street being vacated, was traffic concerns. And we have received a request by way of the local community housing development corporation for possible consideration of rent-owned housing in part of the southern portion of Centennial Park. That is not part of the decision that's before you today, but felt like in the interest of full disclosure, at least need to make you and the community aware that that request in a timely manner has been received about the same time as this vacation request. What we've done is asked the engineering department to look at traffic flow in its current condition, as well as if that development were to play itself out, and render an opinion about whether that would create a concern from a street design traffic flow standpoint, and they've concluded that it wouldn't. In the staff report, item number 6, we elaborated a little bit further in terms of the process involved with the Chodo request, and that's all something that would play itself out in the near future, unrelated to this request. We would need to make a determination about our level of interest in considering that as a possible location, the process by which we would want to, if you chose to go forward, the process by which we would solicit a proposal or multiple proposals, and then there are additional procedures as it relates to declaring parkland surplus property and disposing of it. So you're not being asked to make any decisions on the Chodo request today. Just wanted to make you aware, and as I said, in the interest of full disclosure, make the neighborhood aware that request is forthcoming, and they kind of interrelate. But it is not something that's directly related to the request before you today.
I do not have it to put up on the screen, but you have in your packets here a sheet that summarizes different lot dimensions. And I just wanted to clarify that the current Rod's convenience store site has 24,000 square feet, and it's 110 feet deep. And if Cypress Drive were vacated, it would become 237 feet deep and have 52,000 square feet. And what that would be comparable to is if you're looking at areas along South 9th and other commercial corridors, it would be rare to see a commercial platted lot that would be less than 250 feet deep. So the 237 feet of depth and the 52,000 square feet would be pretty comparable to what you would have on a South 9th or a newer platted location. And if you were looking at the area east of Birch Drive, it presently has 19,000 square feet and is only 110 feet deep, and it could be deepened if half the street was added to 16,000 and up to 19,000 if the full depth was added. The other challenge about those lots on the south side of Cypress is that they are only 67 feet deep, and that's not really conducive to standalone development. I guess when we looked at this, and I know when the Planning Commission looked at this, they called it infill development. And if infill development is development in an established existing neighborhood or any development that's not out on South 9th Street, then this would probably qualify as infill development. But this also points out two things: the importance of platting, because what happened in the 1970s is that the zoning was changed on these lots, but they weren't really deepened or repackaged to make them. And I've had several site visits and several visits with Roberta Kaufman over the years, and she said, nothing ever happens on these lots. I can't get anybody interested, and it's because they're too shallow. Mm-hmm. And so if in the 70s this was looked at as being converted to commercial development, this actually was discussed in the 70s about closing Cypress Drive and getting an extension, but for whatever reason it didn't happen. The other thing I think it points out, and Mr. Mays would probably agree with me, infill development is a lot harder to do than developing on a vacant lot on South 9th Street because of some of these constraints that you have to work with existing platted lot sizes and existing utilities. So this does come to you with a recommendation of approval from the Planning Commission. Their recommendation would be what you be described as option 1 or alternative 1 in your packets, which was to take the vacation from here and include that area and dead end Cypress there, but not including behind Hickory Hut. There is another option, and that would be to say extend Birch, eliminate this, and leave this just as it is. That is an option that's identified in number 2 there. Third option is to deny it altogether, which would leave everything just the way it is. Or a fourth option, you could postpone consideration of this petition if you feel like you need additional information from staff or others to reach a decision. But the recommendation that the Planning Commission made would be best described by alternative 1 there with those 6 conditions. And the ordinance that is attached is based on the Planning Commission's recommendation. I do know we have Jeff Mays here representing the Kaufman family, and I think Don Mars is here representing Hickory Hut, and so he could better describe Hickory Hut's feelings than I can. So I'd be happy to address any questions that you have, or otherwise we could hear from others.
At this time, do we want to open it up to public hearing first? Do you want to question Mr. Andrew?
Has anyone sat down and maybe
Mr. Mars can tell us this. Has anyone shown this photo to the Blakes? Because it looks to me, if Cypress is vacated and folks accidentally turn onto it, or folks that park on Cypress are going to want to turn around, they're going to shoot right through the parking lot at Hickory Hut.
Well, that is the idea for why on new dead-end streets or newly constructed dead-end streets that you provide a cul-de-sac or turnaround at the end of that so that you don't direct people who don't intend to go there onto private property. If the entrance there at the intersection of Cypress and Comanche were posted with a dead-end, no outlet sign, that would discourage some people who didn't intend to be there, but you're always going to have that situation unless you do have a cul-de-sac or some sort of hammerhead turnaround.
I just wanted to make sure the Blakes were aware of it when they made the decision that they didn't want the whole road.
Yeah, and I think the second letter from the Blakes, their first letter indicated they were opposed to this. Their second letter, I think, indicated that they are opposed to this also. They'd like to keep the whole thing open and available.
Of the, I think you said 163 notices went to property owners. How many folks showed up at the Planning Commission meeting of the 163?
I think maybe there were somewhere between 10 and 15. A couple of them were couples, both husband and wife spoke. But I think the minutes reflect a pretty good cross-section of who was there and spoke.
Okay. Additional questions of Mr. Andrew?
Yeah, I've got a few. The alleyway, I know before when we sent it back, the alleyway, can you throw up the plat map there of the neighborhood? Yeah, where you showed the easement for the sidewalk that's running east and west, it also shows an alley easement as well, is that right?
Well, what this was intended for was, again, going back, because these blocks were so long that when they were platted, the blocks were platted with breaks right here. With this is, you could call it, it's not for vehicles, it's for pedestrians or bicycles to go from here to here between the blocks. You could call it an alley, but the owners of those lots own the underlying property, but subject to that easement.
And it's built up in between the backyards of the houses.
In some of those areas, there are fences and things, because not every mid-block area did paths or sidewalks actually get built. So some of them have fences or are grown over. They're there on paper, but they're not developed with improvements.
You use the term deadhead, or what did you?
Hammerhead.
Hammerhead. That term to me kind of invokes these extremely ugly concrete barriers. What can I see in my mind that's different from that? I mean, what would we really do to close off the end of that street without a cul-de-sac?
What would the barricade look like?
Yeah.
Well, I think that's important. I don't know that it got reflected, but one of the planning commissioners commented that they knew there had to be a barricade, but they hoped there wouldn't be just an ugly concrete Jersey barrier put there. And so that is a judgment call. That could be part of the review of actually closing and eliminating the street. But if you could go back to the aerial photo, Dustin, and most people do not drive by the entrances to the hospice on Holly Lane, but Holly Lane is a dead-end street south of Crawford. At the south end of Holly Lane, there is a little notch right by Hammerhead. Instead of a full circle, it's like a rectangular notch, and you can come, pull your car in, back it out, and go back out.
Okay.
So that's what's meant by a hammerhead, as opposed to having a full circle. You come down, you come here, pull into a notch, you back up, and you go back out. But a hammerhead is designed for very low traffic streets and infrequent You don't need the full turning movement, but we have, you probably don't have the full GIS, but I gave example of the packet. Most people don't know that there was a street called Shady Bend Drive that used to connect Crawford with Beverly Drive, and the Comfort Inn Motel is built over the top of it. Well, if you go down Beverly, there's a little stub of Shady Bend Drive that's left, goes about 150 feet, terminates in a barricade, and has a little hammerhead there where you can turn around. And so it would be similar to that, but a hammerhead generally can fit into the existing right-of-way, whereas a cul-de-sac, to build a full cul-de-sac here, you'd actually need more right-of-way than what is available. You'd have to make it bigger and come up like that. So that would be a space eater if you had to have a cul-de-sac.
And in the terms of opening up Birch and closing and the sidewalks and curbs and new street, who bears the cost of that?
That would be strictly with the development group that wanted to redevelop that, and that was one of the conditions of the Planning Commission's recommendation, was that all the costs for constructing Birch Drive would either be borne or assessed back. So if you did a benefit district, you would assess the cost to this lot and to that lot. And they would pay for the cost of the street and the sidewalks.
The only other thing is, give me a little bit of a feel for what's underneath, what if Birch Street was extended, what's underneath there now, and then what's just to the east of that. I think one of them's an abandoned house pad, and the other one is still the old house. Is that right?
Yeah, this house here was converted into a drive-through for Hickory Hut, and that was an existing conversion. And then this right here is a pad. It's just a slab for a house that was removed, but the slab is still there.
Mm-hmm.
And Dustin, you've got some photos there at the bottom, right? I think that is what Cypress looks like looking west towards Quick Shop. And I think the other thing we point out, the depth of the Quick Shop lot goes to about right here, and they've had some discussions with us about doing a tear down and build back, but if they did, they would push the building farther back. Their zoning goes just about even to the back of those lots on Cypress. But this is the view looking back west. That's the slab that's left behind in the background there. So that's looking from Crawford, and that's the slab. And then over here was where the Hickory Hut drive-through was before they moved in 2003.
And that's been vacant since 2003?
The site where they were operating out of has been vacant since 2003.
From the Kaufmans, and when you come up, it'd be, this might be a question ahead, but do they have any interest on that property that's as active as the interest on the west property? Okay. Thank you.
Excuse me. My question, go back to that aerial. I believe it was, yeah. If the street goes to Birch, I take it that there'll be a barricade there. If it opens all the way up to Crawford, but it's closed to the east, will there be a barricade right almost where that little hand is right there? Right there. Will there be a barricade there?
You would just have a curb line. This would just be a curb starting here with there would be a curb here and
a curb on there. Okay. So on the other side of the street there will be a dead end sign, and there will be no room there for a hammerhead. Is that correct? Will there be?
There is. If you did the right-of-way preservation, you could potentially get a hammerhead, say right into here, and get it to fit within that right-of-way. There's 33 feet of street and 60 feet of right-of-way, so there's room to put a partial hammerhead in the existing right-of-way.
Okay, my question is, though, if you go all the way to where the hand is right now, that means that lot has the room to be developed all the way down. Until that is sold that way, it'll stay open. Is that correct?
all of Cypress will stay open until they've got actual prospects and they're ready to actually build Birch Drive.
So it's considered one whole thing? You can't piece it into two things?
It could be done in phases. It could be left open. That would be up to you as far as the second, what would trigger second reading. But
Okay.
no final approval would happen until something on the development side actually happened.
Okay.
I'm not sure. Mayor, if the commissioners are finished, I have a few questions. I want to make sure that you've had your opportunity.
Mr. Andrew?
Yes.
Okay, go ahead.
Dean, the whole question of timing, I understand that when site plans are approved, that then the sites can, be made to conform with the zoning code and all the other codes we have, whether it be buffering or other things. But let's say, for example, that we anticipate a project, let's say on the west side, but not on the east side immediately. And are we really going to be looking at a street, physically a street without right-of-way that's only going to be separated by a curb, and we really don't have any green separation or anything there? In other words, we could have that situation, almost in perpetuity, couldn't we, without some type of a development agreement that says if the properties don't develop within a certain part or a certain period of time, then certain restoration would have to occur?
If you ever got to that second reading and physical removal, yes.
Okay, because to me, that's a concern. I see, when I looked at the maps, I first saw the residential area, and I saw how, quite honestly, I don't think that at the time the city took into consideration the need for the depths of the lot, of the commercial lots, which you made reference to. So that was planning mistake number one. This should have been dealt with at that time, in my opinion. So now here we are again, and we're dealing with the depths, but I don't know that if something doesn't happen, that we're necessarily dealing with what's there. And if this was all green space and new development came in, we would say, well, we don't want it to look like that. We don't want it to look like, this. So my thinking is that there should be some burden on restoration placed on the property owners or developer or whomever that actually is, that if it doesn't happen within a certain period of time, so that any of the, in essence, temporary looking barricading and temporary look of a street that goes through a private property that just doesn't look like it belongs there would actually be restored, and it looks like it's a natural part of the natural feature of those lots. That's kind of my concern.
And that was why I asked that question. If it stops right there at where that little hand is, if it stops right there and that's where the curb is, until they develop that land, I take it that street stays open. And so shouldn't there be a time limit or a time frame as to how either there has to go through a restoration process or it has to be developed so it doesn't look, what's the word I want, undone?
Yeah, and I may have misunderstood this point, Dean, so please clarify for me if I did, but I'm presuming that if the city, you're talking about the second reading would come on the actual development occurring, right?
Right.
So that the first reading just sits out there, for no predetermined period of time, just until something happens. So therefore, we do first reading, that's always a public street until we have a site development come to us.
And the other option would be that if you get to second reading and you have a firm development for the west and nothing for the east,
Okay.
then the option is always that you only give second reading approval to
the
this
west.
section and leave this just as it
Okay.
is and
Okay.
don't
Okay, I'm
vacate
getting
that.
it.
So that does eliminate the timing issue.
So second reading really is the real gatekeeper for, you could always say no to the east on second reading if there's absolutely nothing that materializes.
Okay.
Or correct me if
purpose-
I'm wrong, the applicant could also, at that time, volunteer to take up that roadway and put it to a restored condition, even though they may not have a development plan.
Even if they did not have a prospect for the east, they could take the road out, restore it to green space.
That was
and
my
leave it
concern. That was my
at
question.
that point if there wasn't,
So that could be required on second reading through a development agreement in essence?
or just by changing the conditions or because what first reading would do is tell the Kaufman family and Mr. Mays that they can go out and seek proposals for that configuration, and if nothing is produced, then nothing happens, then the street never gets vacated.
Right, okay.
Within that agreement, could the agreement also be crafted that if the west occurred first, not only the road, but the property that remains at the east, so i.e. the old original Hickory Hut location and the abandoned concrete pad and other things on that property be dealt with as well. I guess the statement that I'm making is if this were done and there was a nice new piece of development on the west side, then I would hate to look at the map and say, well, the north side of Crawford's all cleaned up and everything except for that one lone piece of property, because we didn't ask the questions or try to put an agreement in that would address it.
Yes, you're saying that not only to deal with this piece here, but you could say, we want you to clear and groom this site so it's attractive and
Correct.
not
Correct.
looking, that could be done as part of that. Like I said, you have the option now of just approving this part and not this part on first reading, but when it got to second reading, you would always have the option to say no to that because there's no prospect for doing anything over there.
Okay, I understand.
Dean, on the timing of this, let's say that first reading's approved today and second reading waits until a development opportunity, and that development opportunity comes about 3 years later. At that point in time, it's possible you have a different governing body, and so we've kind of thrown that first reading out, and then the development opportunity comes around, and the next generation governing body says, I don't agree with it, I'm not going to do it. Has that been discussed? And it kind of prompts the question of why wouldn't you have the development opportunity in hand, and you might at this point, I mean, it might be in hand on at least part of it, but why wouldn't first and second reading be coordinated with the development opportunity rather than leaving first reading out by itself?
Well, I guess Greg can speak to the term conditions precedent, but it's not uncommon on whether it's a plat or between preliminary and, this is almost like a plat where you'd have a preliminary and a final plat, and this is the preliminary version or preliminary approval, and there are a number of conditions precedent that I guess the best way to address that is to not leave it dangling and to put a time period in the approval that if there is no site development plan or development proposal within 12 months or something of that nature, that would also not result in a second reading, because you wouldn't, if it takes 3 years or 5 years, whatever, then this is a whole lot of work for not a very good prospect. So one would like to think that if there would be something that would happen within at least a 12-month period, but I guess the best way to address that would be to say that if there's not a proposal for a site plan and a building permit on one of these sites within 12 months, then it would simply be repealed and go back to the way it was.
Because this is the public hearing, and so on second reading, would there be a public hearing?
There wouldn't be
So-
one required, but
Okay.
we could do one.
But if we didn't do one, theoretically, then you could have a different governing body, possibly different neighbors, and no public hearing at that time.
Exactly. How does that work? Well,
I mean,
go ahead.
I'm sure you recall the details better than I. Is that 1 year period fairly consistent with any other circumstance?
that would be consistent. We've had one case, well, we just had one recently where the Planning Commission granted an extension. There was a preliminary plat that was approved, and that plat was good for 12 months, and you had to file a final plat within 12 months. The other one that comes into play is if you get first reading on the rezoning of a piece of property, you've got to plat that property within 12 months. If you don't, then the zoning goes away. So we've had that happen on a couple projects where we had a preliminary plat, you gave first approval to a ordinance rezoning the property, they didn't pursue the platting within 12 months, the first reading was repealed and it went back to the way it was.
Okay.
So that 12 months is consistent with what we require for plats or other types of things. And this, to a degree, this is like trying to replat the property, but it's being done by petition instead of by plat.
Okay. Additional questions of Mr. Andrew before I open it up to the public? Okay, thanks for now, Mr. Andrew. At this time, I will open it up to public.
Good afternoon. Jeff Mace, Compro Realty, 157 South 7th. I'm going to address some of the questions that came up through Mr. Andrews' presentation, and then if you'll allow me, I'll reserve the right to speak again if necessary. First of all, I guess it's important to note that we're in complete agreement and have no issues with any of the 6 conditions that the Planning Commission set forth, so you'll see all of those things obviously occur. From a timing standpoint, let me explain to you the current state of affairs. We have an agreement, signed contract, both parties, both the tenant and the lessor, Mrs. Kaufman, are contractually bound to move as soon as we get this process taken care of. There is a matter of due diligence on the tenant's side, but it's reduced to some very few small items at the end. They basically are waiting to make sure we're going to get the street vacation before they go out and spend those dollars. Okay. So on the west side, that will happen immediately. In fact, it was slated to happen at the January 2nd, and just from timing issues and going back to Planning Commission. So that deal's done. In regards to the east side, we had been working with another group, another national tenant, another national name, not in fact a restaurant by virtue of the size of that lot, but another national brand. It took us a very long time to get our contracts executed between the tenant and the landlord. And in that delay, which we were waiting to get that done before we came before the Planning Commission, and you all, we've kind of tabled them. Things have changed, as y'all know, in the last year, through 2009. I talked to them probably 8 months ago. There was still interest, but I told them once we got through this process, I would tee them back up, because I kept telling them I thought it'd be 30 days, and 30 days would turn into 60, and I said, let me call you when we get it done. In the name of not over-promising and under-delivering, I can't tell you for sure what that would take. The reason that we're requesting the vacation in the form that we are is that so that if we know that that's done, we come forth with a site plan, get that approved in second reading, and not have to go through the complete vacation process for that other piece of Cypress.
Okay.
Does that make sense? Mm-hmm. We have someone in mind. The other piece of it is the fact that in its current state at 110 feet, it's just not recognizable as an opportunity to develop. So.
But can I ask, if it doesn't come through, what is going to happen to that east lot?
We would be fine. Perfect world, and we're fine with the 12-month restriction, because I certainly get Mr. Gage's thought process there, and not having a curb running through there and whatnot.
Right.
We would be perfectly fine with immediately, building the Birch Street and only putting the curb on the west side and leaving Cypress open until such time we bring those folks to the table, we've got a site plan, then vacate for the depth. And that's when the curb would go in on the east side of Birch. But it would remain fluid until such time we have that agreement executed.
Okay. And 12 months is a reasonable amount of time?
I would be okay with that. Well, given the fact that, given the fact that that Cypress is going to stay open, and just have it for the property owner knowing that they can access that depth when they need it. We don't have a situation where it looks undone. It just looks like it looks today,
right,
with the west side developed. So it really continues to function as it functions today.
Okay. Okay. Questions of Mr. Mays? Okay, thank you. Additional public comment?
Hello. I'm Sue Herman. I live at 741 Willow Drive. And I'm here again to protest the vacating of Cypress. When we attended the Planning Commission meeting in January 5th, Mr. Andrews was talking about the pedestrian easement in mid-block between Cypress and Plum. I walk that street every day, and I'll be darned if I can see how there's a clear pathway over to the park. There's not. These lots were zoned commercial back in 1974 on the south side of Cypress. And for whatever reason, and I think I understood Mr. Andrews to say that part of the problem was the issue of the depth of those lots being developed commercially at that time. And my question is how come Mrs. Kaufman didn't go ahead and get it back to residential, where housing could have been built there. I don't think the Planning Commission made it very plain to us that their decision was for the good of Salina, and we are Salina. And I don't think this is good for us, chopping up our neighborhood this way. I don't think, based upon the easement that's supposed to be between us and Plum, is not there to walk through. I mean, it's been built up. I mean, that's the homeowner's faults and stuff, but I'm really worried that the pedestrian easement that has been proposed for this development is not going to be kept up, and we're not going to have access that we had before to the park. But I think it's sad that the only ones that are going to gain from this, I don't think, is the city of Salina or the residents of our neighborhood or Rod's, and I don't know how that's going, but I just don't think that anyone is going to gain from this other than Mrs. Kaufman and the real estate developer. And then Birch going straight through is, I think that's going to be a mess, guys, because it's a mess can be a mess. Willow getting out onto Crawford, and people coming in from the interstate, if they go to whatever fast food chain is going to be there, and the access is on Birch, and then coming back out, and then trying to get back out on the highway, back to the highway. To me, it doesn't make much sense because of the congestion. And a good example of that is if you go down by Walgreens and the way that access in and out of there, people trying to get out on Crawford, and that can be a zoo sometimes. But the safety concerns, one thing I do want to say that no one requested sidewalks to run the length of the park. That was something the Planning Commission came up with. The sidewalks up, if Birch was running through, was part of that, but we did not ask for sidewalks running the length of the park. And that came up because Mr. Householder told us to keep the kids out of the street and take care of the speeders. And kids are going to run in the street sometimes, no matter how many times their little butt's been spanked. No, but it'll they just get carried away and they take off after a ball or whatever. But yeah, the speed is a concern. And I want to thank all of you for listening to me. Again, I'm just a selfish old gal that would like to keep our neighborhood together. Thank you.
Thank you, Ms. Herman.
Mayor, Commissioners, I'm Don Mars. I'm with DMA Architects, and I represent the Blakes who own Hickory Hut. First of all, I think Mr. Andrews is definitely correct about the whole issue here has to do with lot depth. And the lot depth was decided back when this was platted, so even though it's the biggest issue that we face, it's still there and we still have to deal with that in dealing with what we're dealing with today. With regard to, I think it's interesting for me to convey a little bit of the timing aspects with regard to this concerning the Blakes and their position, because there were two separate letters that they submitted to the city manager's office concerning what they felt their rights were. The first had to do with the initial request for vacating, and they were advised by Mr. Andrews that they could join the petition, or they could choose not to join the petition, and if they chose not to, that the portion of Cypress behind their property could not be closed. It wasn't until after the second Planning Commission hearing that we discussed the whole issues with regard to what happens with Cypress if it's closed behind their property, and this whole issue with regard to the subdivision regulations which the city of Salina has adopted with regard to street design. And it doesn't say that it's just for new construction. It's the guidelines that the city follows for all street construction. So it's my opinion that when you permanently dead end a street, that you have to provide some form of turnaround for the vehicles that are on that street. The dead end street requirements has a limitations as far as maximum length, but they don't have a definition in it as far as minimum length as far as a dead end street. I think that today you have the option to approve your item number 2 as far as the staff's recommendation, which would close the west half of Cypress. My client has no problem with that, nor does my client have a problem with Birch Street being extended through to Crawford Street. You have, you're charged by state statutes that no privilege or rights can be taken away by your action today. Mr. Andrews' reference to that was primarily on a residential perspective, but I also contend that's also on a commercial perspective as well. Commissioner Angel pointed out that traffic that ends up on Cypress can't turn around. They would have to go through Hickory Hut to get out to Crawford. And I point out that that's a one-way drive in off of Crawford. Parking is diagonal, so people have to exit onto Cypress Street to get out of Hickory Hut's parking lot the way the parking is laid out. That building was moved in there. That was the old Skipper's Seafood building that was out on the north side of Crawford near the control dike, and it was moved in here by Mrs. Kaufman and positioned here, and then the Hickory Hut has purchased it from them. So they're limited to the property that they were able to purchase in dealing with that. So their business will suffer if you choose to close Cypress Street between over to Birch, or at least behind their property, because of those particular issues that we're dealing with. I guess I would recommend that if you choose to proceed with this today, that you choose staff recommendation item number 2 with regard to the action that's being proposed here, and that would not hamper the Hickory Hut in their current existence on their property in the subdivision. Any questions?
Mr. Mars, in helping them with their property, was it ever discussed, or did they ever look at possibly building their business out over Cypress on the vacated portion of the street on their property?
We discussed the benefits, the pros and cons of vacating Cypress behind them and turning that into their property, which obviously
additional parking, or
that is those are the positives. The negatives that they saw had to do with the park use. And I would say also that if Cypress continues, you have traffic that circumvents that park. You have a way to get clear around it. Otherwise, you're one way. If you come in off of Crawford to the park, you can't turn and go down Cypress if it's closed. Park use is a big issue for them. There's a lot of skateboarders that use the park behind them, and they feel like having the street there, that creates still some buffer between their property and the park.
Dustin, do you have a picture that shows a little bit more to the east?
An aerial picture?
Anything, just so we can see. We can just see. Yeah, I want to see. There you go. Okay, so right now, where are they on those numbers? Are they 5 and 6? 5 and 6? Okay, and then.
Yeah.
Pardon me?
It's 5 and 6.
It's 5 and 6?
Yes.
Okay. So if they were to build out to the south on the vacated street, you're saying, and the park is right there, I think, are there trees right there on that northern edge to buffer the park from the street, or is it open? It's open?
Yeah.
There's a couple.
Yeah, Mayor, that if you're going to develop that ever and expand, you certainly could put in buffering, which could be trees, berms and trees, fencing and that type of thing. Now, without question, there'd be a cost to for them to do that, but you could buffer other ways. I mean, actually vertically buffer.
To the owner. The owner or the developer would have to.
Well, the way it's set up right now, I would anticipate that being the case. Quite honestly, it all depends on if there's a negotiated agreement on who pays for what, and that can happen in these types of cases. But I guess my point is that there is a cost to it, but there could be vertical buffering versus just this horizontal buffering we're talking about.
Well, here's my question. If Hickory Hut also builds to the south, over the vacated street, what happens to, is that Comanche that comes around there? What happens to Comanche and Cypress? What happens to that intersection right there? How does that
That
look?
intersection has to remain. It's basically just a corner, and Hickory Hut would not be able to take any of the right-of-way of Comanche. They're only taking the portion of the right-of-way of Cypress that would be
Belong to,
vacated.
correct.
So they're not gaining the entire width of their property. Their drive-in lane currently is on the east side of their property, almost in line with that. So, there's no benefit to them. Matter of fact, that intersection has to remain, and that even becomes even a little more difficult for them because of the way their driveway comes in there now. Right now, Cypress is a straight line on the north side. If you take and take that out and you end up creating a curved corner.
Right.
Their driveway is right there on that curved corner.
Okay, that's what I thought.
There's no
Okay.
benefit to them with regard to that. Matter of fact, it's a detriment to them.
Well, the day that I drove by, their parking lot was completely full, and the street behind them was completely full on both sides. So I totally understand that they don't want that street vacated for parking.
We have, when we designed their building and we put it into place, stacking of vehicles in their drive-up lane is a real issue. And so cars physically come around the west side, go down the south side, around the east side to come back into their drive-up lane, to get into the drive-up lane for the Hickory
And then they
Hut.
have to exit out Crawford, is that
They can
correct?
physically exit Crawford, or they can go back out Cypress.
Okay.
But if you go south, it's one way. If you go, they physically could go
Right.
north because the curb cut is wide enough for two vehicles, both entering and exiting.
Right, okay.
But only exiting through the drive-up lane.
And as soon as they go south, all of that parking is oriented to come in
That's
from the
right.
north.
That's
Now,
correct.
on Cypress, is there a way that Cypress could be made a one-way with traffic bound only towards the east on that section that goes over to, what did we say that road was there?
Comanche.
Comanche, that's coming up on the east side of the park? Yeah, that section there.
They have customers that exit and go both directions from their restaurant. So, making it one way, I don't see an advantage to that. Another issue here in talking about, Mr. Andrews said that you could put a hammerhead in to deal with that. That hammerhead, it's physically going to take up part of the street you're talking about vacating to a certain extent. That there's no design for that at this point in time. But we see that section of Cypress. There's no real gain for the public or the Hickory Hut, the park users, the residents, to see that close, because with it open, it gives you the ability to physically circumvent the park, go either directions from their business as well as the other businesses east of them. And they're stuck with the land that they've got.
The design of that hammerhead, we said was 60 foot, so in essence, it's a portion of the right-of-way within the Hickory Hut's lot right now, right?
It depends on how you design it. You would physically probably design it to go, the hammer part would go south off of Cypress, and that would take up part of the right-of-way of the park.
Okay.
Mm-hmm.
Or both.
Additional questions of Mr. Mars? No.
Thank you.
Thank you. Additional public comment?
Yes, I'm Alvin Casper, live at 727 Willow Drive, and This is turning into quite an interesting little adventure here. For what's all being stated, it sounds like that the west part of the Cypress deal is pretty much cut and dried. I really hate to see that because I think Rod's is a very successful business there. And if you go by there, there's always cars and there's always something going on there. So as far as Mr. Householder talking about businesses dying, I don't feel that Rod's is dying. I think it's very alive and I think it's very well. And so as far as just eliminating it because it's an old building, I think that's really a poor decision. But, you know, that's Kaufman's decision to make, I guess. But you guys, or Mr. Andrews, considered all the right-of-ways and stuff along the north side of the residences as far as access into the easement and all that kind of stuff. I still feel that I do use Cypress quite often, more than what I really realized, and so I'm still against closing Cypress on the west half. But if it all comes to pass, I would really like to see the east stay open just for access to the park from Birch and from Choctaw. But the way it looks to me, like if Kaufman's could give the Blakes a good deal for the lot west of Hickory Hut, then that would give them a lot more parking and eliminate a lot of the congestion for parking on the street, as well as trying to get through. And then if they would purchase that, then you only have a really short distance of Cypress between Birch and their property. And then I think as far as your hammerhead goes, I think that should all be not even considered, because then you would have full traffic flow going around the park. And even with the discussion of the Blakes getting half the street and building over half the street, the park's going to get the other half, supposedly. And so what's the park going to do with half a street? You know, they can't develop another play area. They've already got the skateboard park there. They've got the basketball court. And so, you know, they're pretty well set on their property. So I don't think they're going to gain anything at all by closing the west part of Cypress. So in my opinion, I think you should just leave the west part of Cypress, or the east part, I'm sorry, the east part alone, and just leave it totally accessible. I think the businesses can survive on the depth of the lots as they are. Hickory Hut's very successful, Rod's is very successful, so I don't really feel that unless the Arby's comes in, and I really have a hard time seeing that Arby's is going to be that much of a benefit to put it there on the west side of Salina. You know, they have a store there on Broadway, and I've been there probably 4 times since it's opened, and I've lived in Salina for 22 years. So it's not a big deal to me, but I guess I just feel that Rod's would be a better business to have right there. And I guess as far as the park, you know, the knowledge of the park being there, I know that in some of the other motels that I've stayed in like Kansas City and Manhattan and stuff, they have a little map there that you can access the city, all the highlights, and you know, it is accessible. You know, they trying to paint the picture that they need Birch there to access Crawford to be able to get to the park. Well, I disagree. You know, I think that the park is very accessible, and I just, you know, feel that it's okay. but I still am concerned about the safety and of the children. You know, I got a 2-year-old or a 3-year-old granddaughter, and we go to the park, and you know, there's a lot of other kids always there. The water park is always busy during the summer, and there's even kids playing basketball and stuff, and their balls bounce out in the street, and you know, there's just a lot of stuff going on there. So I understand that Salina wants to grow and prosper, but I guess that's another item that I have with the development on the south end of Centennial Park. From what the pamphlet that I got from Mr. Andrew, they're talking about low rent-to-own housing. I understand that there's a lot of people trying to make a living here in Salina, but that's kind of where I feel that maybe some of our city fathers may have fell short in attracting bigger businesses to pay higher wages, because for what I've seen grow in Salina in the past 22 years is restaurants and motels, and I haven't seen any major factories, you know, anything that pays $15 an hour on up. And so it's really hard to attract skilled people, if you will, and generate the income, you know, off of that particular employment. But I just feel that we need, if we're going to grow, we're going to have the bigger companies. You know, I know that UPS wanted to put a distribution hub in, and that got nixed. And I know that the John Mansville, they wanted to come in with their fiberglass factory, and that got nixed. And I'm sure that the wind energy that went in down in South Hatch, I'm sure they were discussing it. I can't say that for sure, but I'm assuming they did because of the interstate access that Salina has versus what Hutch has. So, but I think the city, if it's going to grow the way a lot of the people really want it to grow, things are going to have to really loosen up, and we're going to have to get some major corporations investing in our city. And I don't know what all the little amendment or amenities are on some of that stuff, but I understand that there's a lot of tax delays, or where they get where they don't have to pay taxes for a few years, 5 years, 10 years, whatever. But I don't know what all it's going to take to attract that type of business, but I think we need to be looking into it if we're going to grow. Thank you.
Thank you for your comments.
Can I ask Mr. Gage something in follow-up to what he said? Something just popped into my head while Mr. Gasper was talking, in that Jerry Ivy's on the corner of two really busy streets, and that park is always swarming with kids, and I don't think there's a fence or any kind of barrier around
No, there
the
isn't.
park at all. And I don't recall seeing any issues with kids getting hurt or hit by cars running into the street. Do you?
No. Generally speaking, when you look at this, most of the traffic you'll see will probably be going to the same destination that the traffic goes to today, which would be the neighborhood. So, I mean, I think one of the benefits is that when you look at a neighborhood area like that, is that regardless of where the source is, whether it's, or the traffic source, whether it's from Crawford on the Birch or the other street, the folks are going to the same place, and they live in a neighborhood, and many of them have kids, and they're already watching out. So I don't think this adds a different type of traffic, so that's a good thing.
Okay.
Thanks.
Additional public comment?
Hi, I'm Cindy Schroll. I live at 17 Crestview. I do work for Rod's Convenience Store, and I occupy the office that is on the east end of that building. I would say that I am addressing the issue of the effect this will have on actual people in Salina. I spend a lot of hours, both day and night hours, in my office, and I have a wonderful window that I look right out at the park. And I watch huge numbers of kids, and I'm talking kids from age 5 to kids to age 50, playing basketball and skateboarding and just playing on the equipment. And I do see them dart out into the street. And I see them walking down the street to get to the park. I see a lot of teenagers using that street to walk to go over to the existing fast food restaurants so that they don't have to walk down Crawford Street. That Cypress is used a lot for bicycling, kids going from one part of the neighborhood to the other. And I think that you are going to affect a lot of lives if you decide to vacate Cypress Avenue. I think that this is a great situation that exists right there, the way the park is and the street is. And I believe that we should be supporting our local businesses above all. Excuse me. And I think the citizens I've talked to agree with me on that, and I just hope that you will agree as well that we should be supporting the citizens and the small locally owned businesses. Thank you.
Ma'am.
Ms. Shaw?
Commissioner has a question.
I don't know if Rod is here, but I haven't heard what the status of his lease is with.
The lease was allowed to expire pending this right here. If the street is not vacated, then another lease will be pursued with Roberta to keep the businesses and to keep my office there.
There's no lease in place right now, though?
Right.
Okay.
There's a lease on the liquor store right now.
Can you come up and tell us in the mic?
You didn't do very good last time.
And you don't have to say a lot, just give us your name. Give us your name and address.
Rod Bradshaw, 17 Crestview. There is an actual lease right now for the liquor store. The one for the convenience store, there is not one right now.
It's the same building, though, is that correct?
Same building,
Okay.
right. They were nice enough. We worked with Jeff and whoever, the parties all involved to extend the lease, so we had a lease there for the liquor store.
Okay.
Basically, yeah. Okay, can I go?
Thank you. Any more public comment?
Ladies and gentlemen, thank you for your time today. I know it's been kind of long-winded, and I appreciate you guys' effort. I'm Ryan Bradshaw. I live at 711 West Ash here in the beautiful town of Salina, Kansas. I am the manager of Real Stuff Liquor, which is on the west end of the building there. Let me start. Obviously, I got quite a bit of personal interest in this, but I've tried to remove myself from that. I've tried to evaluate this from your perspective, because on a personal level, that doesn't concern you as much. So from your point of view, I tried to review everything I could. Let me start with a couple assertions. I know Commissioner Angel just talked about the contract. We've had a contract with Roberta for over 20 years now. It's something that's just been renewed year after year, no questions asked. It's just the way it's always been. Upon pursuing this year's renewal is how we found out about this situation. And obviously it wasn't something that we foresee happening or anything like that, just something that happened to us. Since this has all come up, we have since talked to Roberta 2 Fridays ago. And point blank, Rod asked, if this does not go through, will we still be allowed to lease this property? Point blank, without hesitation, she said, yes, Rod, you'll be allowed to stay here, you'll be allowed to maintain your businesses as they are. And without hesitation, she also said, in 20 years, Rod, have we ever had a problem? And I said, no, absolutely not. Roberta has been great to us. She's allowed us to start a business and to flourish a business. 20 years ago, she allowed my father to start that business by buying his pumps and his cooler. We've since paid back those pumps, those coolers, and we paid for the building and the property with our lease 2 or 3 times over now. Just the cost of doing business. Now, the other assumption is that I've heard is that the city can't tell a property owner what he can or can't do with their property. I agree with that to a point. Obviously, we have ordinances and things like that, and we have easements. But when a property owner encroaches on public property, i.e. Cypress Street, you are given the task of deliberating and deciding on whether or not this is in the best interest of Salina. So you are charged with the task of deciding if what is going on is in the best interest of Salina. This is simply an Arby's versus Rod situation. I mean, if Arby's does not go there, Rod's will continue to exist. If Arby's goes there, Rod's will be gone. Real Stuff will be gone. You're not creating a new business. You're simply moving Arby's from an existing business, giving it a better visibility kind of location. You're not creating anything. You are simply moving and destroying. All right. To touch on a few things that we've heard earlier, arguments for this, what have you. Marketability. I've heard marketability kind of brought up in multiple situations so far today. Proof is in the pudding. We've been there for 20 years. There are very few places in Salina, Kansas that have been anywhere for 20 years. Dale Blake started in that little itty-bitty hut over 20 years ago. He could have moved his new business anywhere in Salina, but he chose to stay on that block. He knows the limitations of that block, but yet he chose to stay. He likes where he's at. It does work for him. Like you said, you drove by, right? When you drove by, it was packed. Come to my liquor store at 5 o'clock. It's packed. Come to the gas station in a morning rush, an evening rush. It's packed. Go to Damaroo. Damaroo is packed on a Friday, Saturday night. I mean, these businesses are successful. They're not limited by the size of their lot. They're working fantastically as they are. And they'll continue to be that way as long as you'll allow them. Now, the question was brought up earlier about interest in these lots in between. We've actually had 3 different situations where we've been interested in those lots. 1, we would like to build a standalone liquor store right there. 2, we talked about car washes right there. 3, we talked about a car lot right there. I know Mr. Blake has also talked about getting the lot right there and developing that into some more parking space. So there has been interest, and there's been interest for 10, 15 years. So that's not something that should be taken lightly. Here's my opinion. Here's the arguments that you can't argue against. Nobody in the neighborhood wants this. Period. There's not a person out there that said that they want any part of this. They believe that the street is a buffer. They like having the separation between their residential property and their commercial property. They want that. They need that. You know, you talked about a 15-foot easement. Okay, the street's 40 feet wide. I mean, that serves as a great buffer for those people, and they enjoy that buffer every day. I mean, she walks every day. Next, you know, there's no promises in new businesses. I'm sure Taco Bueno and I'm sure, you know, Popeyes promised the world. I'm sure they promised employment, property tax, sales tax. I'm sure they wanted everything. How'd that work out? Now we've got 2 more empty buildings on the south side of Salina. You know, you're going to increase Arby's overhead tremendously. What they've got on Broadway works for them right now. Their overhead, their employment, everything works right now. You're going to increase their startup costs and their overhead tremendously with this. Who's to say in 2 years, like south side of Salina, who's to say in 2 years that they're still there? And my opinion is, I mean, you want better visibility for Arby's. We have 2 pre-existing fast food restaurants with great visibility, great traffic. I mean, you're talking about Sam's, you're talking about Walmart, you talk about Lowe's, Target, all in that same location. I mean, you want to talk about visibility and traffic, they got it right there. They can do it without the overhead that they're going to do with this. Next up, local dollar, stay local. You're going to destroy Rod's, period. You're going to destroy the liquor store. Rod's a guy that forever and always has always spent his dollars local. He's made a point to spend the dollars local and keep money in this town. When Lamone's was distributing, we used Lamone's religiously because they were local. Period. We believed in that. You know, Mr. Blake, same thing. I mean, you're not destroying his business, but just sheer numbers game. You're adding another fast food restaurant. He's a person who is going to make money in Salina and keep it here. He's lived his whole life here, and he raised 2 kids in this town. You are not destroying, but you're devastating his livelihood by allowing this to go through. And you are devastating the livelihood of everybody that works for Rod's. We'll get to that. Sales tax and state excise taxes. Last month alone, this complex made over $45,000 in sales tax and state excise taxes. $45,000. that annualizes at over $500,000 a year, $500,000. That is a lot of money. And I know that not all that is returned directly to the city, but at this point in time in our economy, my own personal belief is that the city has a fiduciary responsibility to the state to maximize everything they can. And you can do one of two things. You can just forget that, or you can accept that. And what you're doing is you're making a statement. You're making a statement that we want to be as financial responsibility to ourselves and to the state of Kansas. I think I read an article, $23 million short last year. I know this is a drop in the bucket, but it is a statement, period. Next up, jobs. Arby's isn't creating any jobs. They're simply moving their pre-existing jobs over. That's all they're doing. We have 12 employees. We have 7 at the gas station, or 7 at the liquor store, 4 at the gas station, and Cindy works in our office. You are destroying those jobs. And you're also destroying an income that helps provide another 15, 20 jobs. We just had our Christmas party the other day. We have over 27 employees now, I think, between all of our rod stations. 27 people. I mean, you are removing a large part of that income. I mean, to me, that's just profound. I mean, like I said, I'm going to leave you with this. The neighbors don't want it. You can't guarantee that this new business can be successful. Sales tax, excise tax more than compensate for any kind of financial gain you can see from this. And the jobs, period. You're affecting 12 livelihoods directly as soon as this happens. And if you have any questions, I'd be happy to answer.
I do, actually. You indicated that you all or your dad have been interested in that East lot for 10 to 15 years.
Yes, ma'am.
Mrs. Kaufman refused to sell that to you, or why didn't you purchased it and developed it?
We've been back and forth with her. She bought these such a long time ago that she paid a pittance for what it's worth today, and so her capital gains tax would be astronomical. I mean, that's not something that she's prepared to lose, and so for her, it just hasn't been a great idea. I mean, we don't want to develop something without future ownership right, obviously. I mean, nobody wants to put money into something that they can't eventually have a piece of. I mean, Dale Blake, you know, I mean, he did a great job with what he got. And since then, she's been kind of hesitant on that situation.
She won't lease it with an option to buy or anything like that?
We've been working with her for that. I mean, we kind of talked about that with if this gets renewed, if this is revoked and our property gets renewed, you know, upon, God forbid, her expiration. We've talked about that, but that's not something that, you know, she's prepared
But
to.
it seems like she's eager to develop it, so I can't figure out why you guys haven't.
Yeah.
What's that?
Here,
It
let me
seems like
step
she's
in.
eager to develop
I've
it.
been around longer than he has. Yeah, and if you look at our lease, we had the option to buy this place, you know, first right of refusal. She paid an incredible amount of capital gains. We probably weren't as aggressive with her to get it. This has opened up an options that if it does fail, I'm tickled. This could be a good thing for us. This could be a great thing for us if this did not go through. It did open up some stuff. The steps that she wasn't willing to take before. The land's never been marketed, never signs up. It's never been marketed or anything. And like I said, we've thrown out ideas with her and gone back and forth. And like I said, she took a step here, you know, and it was our fault, and I guess, you know, terrible to be our fault because it's a pretty big price to pay right now. But hopefully if this would fail, if this does fail, yeah, we will be able to do something. But property tax gain was the issue, that she would go in and sell the land to us and give a lease for an option. And I don't want to talk, anyway, I love Roberta, but unfortunately a lot of this is going to get handled upon her death because of tax reasons. And
there's no one here that can talk on Ms. Kaufman's behalf? Just Jeff? Mr.
Well,
Mays?
Jeff is a transaction attorney in this situation. He represents both parties.
Mm-hmm.
I mean, you know, I've talked to Roberta 3 times in the last 3 days. I mean, you know, so.
Okay.
Yeah.
Thank you.
Yep.
Thank you. If we could wrap it up. Any other public comment of something that we haven't already heard?
Mr. Blake wanted me to tell you that there is a significant amount of semi-traffic that comes off the interstate, goes down Willow, Cypress, turns around and goes back. They park on the street quite a bit on Cypress now because they can. There isn't any other place for them to park if they're going either to the hotel or the other fast food restaurants in the area. But they do use that as a turnaround with Cypress.
Okay, thank you.
I just wanted to know if Mr. Andrew could address what Mr. Mars talked about earlier, meaning the regulation that street dead end in a cul-de-sac as opposed to a deadhead.
That section of that requirement is in the subdivision regulations, which means that if you have a piece of property that you are platting today and you are developing it into lots and blocks and streets, if you plat a dead-end street on a subdivision plat, that has to have a platted cul-de-sac or turnaround on it. We're talking about property that was platted in the 1950s, and requirements were different then, street widths were different then. I think his comments are appropriate, that just simply dead-ending that street and not giving any place to turn around is not desirable. I'm not of the opinion that our subdivision regulations apply to pre-existing conditions. It applies to things that are being subdivided today, but it is a good matter of policy not to create dead-end streets that don't give somebody a place to turn around. I guess my response would be that we have a plat for replat of Timberline Edition that's on West Republic, and that was approved with a hammerhead instead of a turnaround, and we had a hammerhead approved on Holly Lane as opposed to a turnaround, and that's because of the conditions that we had to work with of a plat that was done in the 1970s. So there's no doubt when we're starting fresh and laying out newly platted dead-end streets that you must have a cul-de-sac turnaround, but that's not always been the case when you're retrofitting existing conditions.
Okay. Thanks.
But I do think a turnaround there and not sending them into their parking lot is a very good idea.
Mr. Andrew, you might be the most appropriate. A couple of things additionally came up. One was, it seems to me, looking at the proposed possible restaurant that could go in on that west side, and thinking about many trips to Hickory Hut, was Hickory Hut done before there was under a different guideline for parking, under a different code, or is it just the size difference between the square footage or the number of, because you outlined it in here.
Parking requirements are based on your indoor dining area, your seating, and that restaurant was where Comfort Inn is today. That was picked up and moved from the corner of Shady Bend Drive and Crawford to this site. It was the Anchor Room, which was a sit-down restaurant that didn't have a drive-through, and the difficulty on that site that Mr. Mars faced was finding space to have the necessary parking and the drive-through. But by their seating and by the number of spaces, they have the minimum number of spaces that they have to have, but it is not enough at their peak times, and it's a very tight site, but they are not substandard as to the number of spaces that they have.
Yeah, no, I was just, I definitely wasn't implying that, but I was just trying to get a feel in my head, because we've got about half of that Hickory Hut shown for the relative size or the possible complete undevelopment potential of the property that the Kaufmans have right now where Rod's is. In other words, we've heard that it worked once, but we also hear that the lot depths are what keeps it from working. So those two, side by side, are in conflict with each other.
Yeah, I think the reason that people park in Cypress Drive is just because the site is so tight and so congested. It's easier to navigate and park on Cypress Drive than it is on the property. That's not to say that absolutely no way could you build anything of any kind between Rod's Convenience Store and the Hickory Hut. It's just the type of development and the development pattern you're going to get. There's a lot of types of businesses that feel like they have a minimum need that's much greater than 110 feet.
Then, Jeff, I don't know whether you'd answer this. We've heard this quite a few times, that Arby's is just intending to move a business from Broadway over to here. Do you have any knowledge whether that's their plan? They're going to close down one location and move, or have to, or is that something that you?
The tenant at this time is asking me not to divulge who they are.
Okay.
So I've been asked, and I've got the responsibility to the tenant in that.
Okay.
I might address a couple things that came up. One, I think somewhat being implied that Roberta's not in favor of this, and I think her favor of this is evident by her execution of the contract and execution of the petition. Bear in mind that she's the one requesting this to happen. I too met with her last week, and from what I got from her, she's very excited, and the family's very excited about the prospect of this being able to happen by virtue of the position it puts them and the family in. So I wouldn't say that I wouldn't agree that she's not in favor of this occurring, because we're here because she wanted to do it.
Okay, and now I'm really confused, because when this first came up, those were my exact thoughts, is when you have a tenant and when you have a landlord and something is going to happen, I'm sure that there's dialogue that has to take place between the two. However, when you're the owner, the tenant has to realize that you have the right to do whatever you want to do with your property. And I wondered what was the dialogue that happened there. Not knowing, I'm thinking, okay, Rod is ready to do something else, he's moving somewhere else, he's wanting to downsize, he's leaving town, she's wanting to further develop, somebody has approached her or her company or her family, and they're wanting that location, but they're needing the depth of the lot. Not knowing the dialogue that might have taken between the landlord and the tenant, it's difficult to sit up here and to just assume or imagine what happened. So she is excited about developing this with who you're representing, the developer, you being the developer, and yet he is up here saying that if it doesn't go through, she's content leaving the lease as is, and everybody will just go about their business. So I don't know about the other commissioners, but I am really confused now as to exactly what is happening.
Excuse me. To say that Roberta's not in, she certainly empathizes with the fact that Rod's been a long-term tenant, and she, of course she reaches out to that, but this request is on her behalf and in the name of getting her property developed, not only the west side, but also the other lot. I think, it's human nature to, I feel for the situation that Rod's in here, by all means. I consider Rod a friend. But it doesn't mean that Roberta and the Coppin family is not in favor of doing this.
Commissioners, I think Jeff's correct. If they weren't in favor of doing it, they would have rescinded the application. So simply having an application means that's what the owners of the property want to do, regardless of what anyone else says. The owners aren't here to represent themselves, but it doesn't matter. They have an active application here that pretty well states that for themselves. I think the city attorney would like to maybe comment a little bit on that issue.
Mr. Bankston, I do not think his microphone is working. Can you hear him? Mr. Bankston's microphone is not working, so will you just talk a little louder? Or here, Luann has a microphone for you.
I'll just swing over here real quick.
Okay, thank you.
I want to be sure that you all don't feel that it is your responsibility to be the arbiter of this landlord tenancy matter. It is not. You have the application before you. I think the staff report lays out well the issues that you are to be concerned with. But the matter between the owner and the current the current tenant is absolutely and totally irrelevant as far as your deliberations.
Okay. Thank you for clarifying that.
The other thing that I wanted to point out as I was listening is this is very much in line with the comprehensive plan in which the Planning Commission and also the City Commission would use as somewhat of a guide in the idea of redeveloping our gateways. There's a great deal of conversation had about the investment that the city's making at Crawford and we've talked about Quick Shop wanting to redevelop over there and redeveloping this main entrance into Salina. This was somewhat along those lines. I, by virtue of what we do for a living, have been in some of those meetings as we've talked comprehensive plan and look at how we can do things to fit that, and that's kind of where this has come from in these ideas. The 110-foot depth, back then laws were much different by way of easements and landscaping and parking ratios and things of that nature. So it's just a matter of fact. It's not an opinion. It's a matter of fact that I think Dean can agree to. As we talk about the east side, one thing that I would, in speaking on behalf of Roberta, I would like to see you agree to the vacation on first reading with the idea that when we come back, very much what you're seeing with the west side, you would have a site plan that will be approved by staff, and how are we going to address those turnarounds and whatnot. A cul-de-sac kind of mutes the idea of the depth by virtue of the land use.
Right.
But if we could go, and I'm not proposing that it shouldn't be on the Blakes, frankly. It should be, if Roberta wants to redevelop that east side, she needs to bear the brunt of how we're going to handle that traffic and those things. So to set and hypothesize what that's going to look like, you're going to have the opportunity in the fashion in which staff has presented these options to you. If you approve the reading or the vacation on first reading, you'll have the opportunity on second reading to look at how that would all be designed rather than guessing and wondering how that would occur.
Okay.
So, one other thing that I would mention is we would be happy at the point in time, if we know what expenses we have, we can factor them in, much like we did on the west side. We can factor them in to what needs to occur. We'd be happy to provide buffering and things of that nature as we structure the deal in the future.
Okay.
Buffering for the Blakes. If they want a 6-foot fence and shrubs and stuff, all that can be put into the deal for adjacent to them. So.
Okay.
We have some flexibility with that as well.
Okay.
Any other questions of me? Sorry,
Thank you,
this is
Mr.
taking
Mace.
so long.
I know.
Thank you.
And surely there's no more public comment. I think everyone has spoken. Quickly so we can move on.
Yeah, 'cause I don't want to argue back and forth, but somehow it came out that somewhere that it might not be exactly what I'm saying. There is a reason where she may be opposed to it now, but she's under contract. Okay? That doesn't mean she hasn't changed her mind.
Okay.
All right?
Thank you. Okay, with that, I will close the public hearing. Everybody take a deep breath, and I will bring it back to the commission for action.
Well, one of the things that I would just ask for, again, one more piece of clarification. I personally am bothered by the east side property. I'm bothered that if we did what we did on the west side property, we would still have an untouched, unclean, that could run on forever until it runs down property. And that's what happens when you have an abandoned piece of property over time. We do have ordinance and things to deal with that, but do we have, if we split those apart, then these two things into two first readings, as Jeff May suggested, then that would take any guidelines or anything that we talked about in a contract earlier from being able to be placed on the terms when we move forward. Is that correct?
Yeah, I think so. I think you really have a couple options, and even though you have a development plan basically in front of you for the west side, I think if we did place that, let's say, a one-year timeline with regards to how long first reading would be held out, you're safe because nothing can happen there until you get a site plan to review, which could deal with hammerhead, buffering, anything. And if you weren't satisfied with it, you wouldn't need to approve that second reading at that time. So to me, probably the biggest way to address that, if you think that there's any possibility that vacation could work, is simply to put that 1-year timeline on both of those pieces of property, so that something has to come to you within 1 year, or in essence, I suppose it expire. I would defer to the city's legal counsel on what the proper tool is, but in essence, it would go away.
Because I'm afraid for future discussions in here that under a different commission, we would hear the same arguments, except she does own the 2 vacant lots south of Cypress, which is given the ability to orient the property. But with the closing of Cypress, there's always the ability for somebody to come forward and for somebody to say, these lots are too narrow, we have a situation here, we need you to deal with it. And I feel that it's come up under that property owner at this point in time. And I just think to separate them and to say, let's extend the street and deal with the west side, but not deal with the east side, would just invite a future commission to deal with the same thing that we've had to deal through. Start Dean Andrews over at the beginning, explaining it to a different commission.
Well, but I understand that they would have a plan, they would have a development plan or a site plan, and before we could approve that on second reading, we would have a timeline to meet, and they would have so much time, which was the 12 months.
For both pieces.
Exactly.
Or nothing happens on either.
Correct.
Exactly.
Yeah, what the 1 year should cover, you'll all be in office unless you do something horribly wrong, I guess.
Yeah, that was the nature of the question is, okay.
I'm down to about
Should be in good
12
shape
months.
that way.
Okay, yeah. So do you feel comfortable with that, Commissioner?
Yes.
Okay.
And Mr. Bankson, is that okay to put a 12-month expiration on first reading if there's no development or no action, then it expires?
Or
Is
a
that how-
12-month time limit?
I think, Mayor and Commissioners.
Other microphone.
Short memory.
Okay.
The,
That's reassuring.
I think, given our experience, that is a manageable time frame.
Okay.
For either meeting or not those conditions.
Well, and according to the developer, he felt it was
No objection to that.
okay, too. Okay.
I guess.
Anything else? The only other comment I wanted to make before we bring this to a vote is it's no secret where I live, and I live on Key Street, and when we moved in, there were lots of little kids, including mine, on that street. And when they thought they were going to, when they first proposed to open Key Street onto 9th Street, I didn't want to do it, but the city won, and I knew that that was going to increase traffic, and it sure has. People come barreling around Belmont, they go across Key over to 9th Street, and I have now become a shortcut. I'm also by the Belmont Fire Station, and while they do not use my street when responding, when they are coming back, they come down Key Street. Of course, they're not going 100 miles an hour, but it's a lot of vehicles, and it's a big fire truck coming down Key Street. It does something to your neighborhood when you have traffic. And now with Kohl's at the end of my street, there's even more traffic, and it has become quite a shortcut. So I don't know if there's ever a solution when you open and close streets like that. I think what happened today is a wonderful problem to have, because it shows we have a lot of businesses that are trying to succeed or go on. Improvements are trying to be made. We're trying to fix traffic flow. We're trying to open up avenues for improvement. We will always have children. We will always have traffic. I feel for you, but I do not think that if we open that up all the way to Crawford, my personal belief is I do not think the traffic is going to increase any more than what it is currently right now on Willow and what it is currently on Comanche on the other side. And when you get down to the bottom, everything kind of curves around. It doesn't go straight to anything, and the only people that would be using that or barreling down those streets are going to be the children that are there now will be the teenagers that will be barreling down their own street, which is what's happened on my block. So I'm not convinced that that is going to increase the traffic. I think that with the development of the moving up to Crawford and the development of that east block or that east lot, that is going to enhance that property, and I am looking forward to something to happen there, because I think that that is important for that, especially with Crawford and with it being in one of the entryways into Salina. But I am okay doing what we were discussing earlier about making sure the 12-month timeline was okay. Sounds to me like they want to develop the west side. I don't know if this is going to be a win-win, but at least it'll be sufficient until the next commission comes in or something else happens. So those were my thoughts on that. I don't know if any commissioner also has any other thoughts before we bring this to a vote.
I think that the one last thought is it's always, I'd like to definitely encourage any citizen within the community that has input on any issue to do this. And we heard, and the Planning Commission obviously heard from a lot of citizens, and even outside of, and yes, that does make the commissioner's life a little bit more difficult because I know we don't have an announcement as to the possible tenant in here, but at the Presbyterian Manor visiting Mom in the morning, we get quite a few people that ask me when we're going to put in the Arby's out there by their house. So it is difficult because we have heard from both. We've heard safety considerations, and we also heard that that the traffic source is going to come from within the neighborhood until such time that something else would be constructed in the neighborhood. And those things all considered, it does make it difficult to make decisions, but that's what we're here for. And to that, I would like to make a motion.
So can I have a comment, please?
Nope.
Sorry about that, Norm.
Hold that thought.
Okay, hold that. Well, I've listened diligently, and I've read all the reports, and I think the biggest mistake made, not our commission, but was changing the zoning of those lots. And it's caused a lot of consternation on businesses, especially on we want to develop new, and I agree that new development is important. But I also think it's important to protect the businesses that we have here in town. And I do think there's lots of other opportunities to build a new site like this. So I'm personally going to vote not in favor of this for two reasons. One, I think we could have spent a little more time looking at maybe the Planning Commission changing the zoning of those two lots. And that would change the whole site plan. But also, I think we have some additional business owners of Hickory Hut that have a stake in this too, and maybe can take that opportunity now to purchase the property next door and give these people opportunity to maybe negotiate with Mrs. Kaufman if this doesn't go through. So there's my comments.
Commissioner Angel? No? Okay. Commissioner Jennings, if you wanted to make your motion.
Yeah, at this time I would to make a motion that we approve on first reading ordinance number 09-10525 modified per item 2, which would be the closing of Cypress only between Willow and Birch with the extension of Birch Street.
Say that again.
Wait a minute.
Commissioner, I'm sorry. What's your motion?
The motion is to extend Birch Street through to Crawford.
Through to Crawford.
And close Cypress Street from the extended Birch over west to Willow, if I got my streets and directions correct.
Mayor and Commissioner, the only question I had was whether you anticipated the one-year time limitation as well in the fulfillment of the conditions preceding.
Yes, with the one-year time limit on properties on both sides of Birch Street, subject to the 1 year.
So does your motion include closing it on the east side as well, just on the west?
Yeah, not the closure of Cypress on the east, but only on the west.
It's been moved. And if it is not seconded, it will die. So I guess this motion dies due to lack of a second.
Mayor, I would move that we pass on first reading ordinance number 09-10525 as approved by the Planning Commission on January 5th, 2010, with the added requirement of the 12-month time period. So I would move that we approve alternative 1.
It's been moved, but there is no second.
Just, Mayor, just, I don't know what you're thinking, and I'm not trying to presume it. Just from a procedural perspective, that you know that you can make motions and second as well as vote.
And that's what I thought. So I can just second her motion?
If you should choose to, you
And
have the
that's-
ability to do that.
Correct. So I second that motion. So it's been moved and seconded to adopt on first reading 09-10525, which is the option number 1, to close the closure and the vacation of Cypress Drive from the west edge of Hickory Hut over to Birch and then over to Willow. But it is not extending it to Crawford. Is that correct, Commissioner Angel?
It would extend it to Crawford.
And extend it to
yes.
Crawford as well. Do we not say that right?
No, you're fine, Mayor. Just one more clarification, just to make sure that everybody knows the circumstances we're under. This is first reading on an ordinance.
Correct.
So an affirmative passage on first reading of an ordinance would require 3 affirmative votes.
Correct.
I just had a question. If this would fail, can Commissioner Jennings make again his original motion for vote?
In that it failed for lack of a second, I don't believe there would be a problem with it being offered a second time. In that you didn't ever act upon it,
Right.
is what I mean. In that you didn't act upon it, I believe it could be made again.
Okay, so once again, it's been moved and seconded to adopt ordinance on first reading, ordinance number 09-10525, which is the closure and vacation of Cypress Drive from the west edge of the Hickory Hut lot over to Birch Drive and then over to Willow Drive, accepting the through from Birch up to Crawford, and also with the 12-month limitation on, okay. All those in favor say aye.
Aye.
Aye. All those opposed say nay.
Nay?
It does not pass, is that correct? With 2 dissenting and 2 in favor.
Mayor, at this time, I would like to make a motion that we approve ordinance number 09-10525 with the closure of Cypress Street only from Willow to Birch and the extension of Birch Street to Crawford Street for a period of 12 months with consideration of both properties on either side of Birch to be to meet the conditions outlined simultaneously.
So again, your first motion again.
That.
Okay, second. Okay, this motion was made and seconded to adopt on first reading ordinance 09-10525, and it was that number 2? Jason's got a question. Yes, sir.
Sorry, question for clarification. I understood the motion to be what I'd characterize as the first reading closure of the west half of Cypress, not the east half, but would also include the closure of Birch, but yet look at both sides, both pieces of property on both sides of Birch. Is that correct?
Yes. Let me repeat that, or you can say it again. Either way, the blue would be extended. Birch would go all the way through.
And the west side, west of Birch, this Cypress west of Birch would be from first reading would be closed. The section that we show, or any section for that matter, of Cypress east of Birch would not be included in the motion, first
Right.
reading. which means that if there was a site development plan that comes later for that property east of Birch, it would have to go through the first and second reading process again. I'm looking at my legal counsel. Yes. I just want to make sure we understand that logistic.
Then, before I accept that, then could it not be stated that the whole property on the east is a completely separate consideration?
In other words,
in other words, if it has to come under first reading for the property that's on the east side of Birch, then is it not subject to the development on the west side based upon having an agreement on the east side? And that's my whole issue.
You're thinking of the timing of basically what could happen on the west side affecting the east side in the end. Okay. Be looking at a different ordinance for that, wouldn't we?
I'm sorry, I asked that question a couple of times earlier, and I think I misasked it or misunderstood it.
As I understand the objective, it would be to essentially add an additional condition precedent to the east segment, and that would be fulfillment of all of the conditions precedent for the west segment. Is that another way to put it?
For the west segment.
In other words, you don't want to be left with the east segment isolated.
Yeah. Correct. Or the west, we can say if the east was brought out first. We're assuming that the west is brought out first.
So you want simultaneous development.
Now I'm sorry, would the west be subject, similarly, would the east segment be a condition preceding to the west?
Yes.
In English, I know what Commissioner Jennings is, I know what he's wanting to do. Because none of this information has been disclosed yet as to the tenant or the possibility of this development, I think he wants to make sure that if the west side is developed, that the east side doesn't just sit empty or undeveloped for the next 20 years. So I think what he's wanting is for there to be an ordinance that gives you that timeline, the 12 months. The west side, it sounds like, is going to be developed, but within 12 months, or we need to have a site plan for the development of the east side before it is adopted on second reading.
And that's correct, because basically we have a development on the west side already, and rightfully so. We have an undeveloped piece of property that could remain vacant then forever.
Right.
And that's my issue. So I want to make sure that my motion is makeable then, and if that's not under our legal advisement, if that is not advised, then I would withdraw that motion.
I'm going to ask the city attorney a logistical question on the timing. If both sections of Cypress were included in the motion today for first reading, I believe you still have the full independence using your second reading action to do whatever you'd want to do with that lot to the east, which would give you the opportunity to, if you could take the factors of what happens on the west into consideration, you'd be able to do that. In other words, just because you would approve potentially the closure on first reading of that eastern section of Cypress doesn't mean you're obligated in any way to approve it on second reading, regardless of what happens west of Birch.
That's what I understood when I made the motion.
That's what I thought number 2 was.
I see. Well, if I may ask a question before I try to answer that question, and I'll look to Mr. Andrew and Mr. Hobby and Mr. Scragg in their roles in this process. And Mr. Mays may have a thought, too, as to the feasibility of how I understand the approach. But is it fair to say we are looking to mutuality in the conditions precedent as to both tracks in the vacated condition or pre-second reading? Am I understanding correctly that it's either both or none?
It's a very good way to put it.
Yeah.
And as a practical matter, Do we think that
It's practical.
is practical? Either from the regulatory side or the development side.
I guess the only thing that would need to be clarified is if, the way I understand that motion, then the east lot is going to be 110 feet deep because none of Cypress, because if I'm Mr. Mays and this motion does not include the east leg on first reading, I know that I'm going to be having a 110-foot lot instead of a 140-foot lot that I'm working with. I think that's the important part.
But it is
for me to
including the
understand.
east side with the conditions that there be a site plan or some kind of a development plan within 12 months.
That's not the motion he
For
made.
both sides.
That's what I understand isn't that what you're?
I don't think it's what he made, I think it's what he's trying to
So-
make.
Yeah, I do too. I think that's what he's trying to
So
do.
Dean, real quick while you're there, might as well ask it one more question. If, regardless of what happens on the west side, I mean, it could be something that the commissioners agree with, they could approve it, they don't have to approve the east side. So they have every option, every possibility of not approving the east side is still preserved based on the second reading aspect of it. Is that
Right.
correct?
Under alternative one, where you recommend approval of vacation of both legs, they could easily, one could be pulled from the other, or you'd still have your options preserved at second reading under alternative one. Under alternative two, what that was designed to say is we don't want to give any thought or consideration to vacating the east leg ever. We just want to keep it open, and the only part that alternative two deals with is the west leg, and that means the east leg stays just as it is.
Yeah.
You asked me.
Can we let him help clarify this? Mr. Mays?
Jeff Mace, Compo Realty, 157 South 7th. I think we've got an immediate need for Birch Street West. What we had talked about earlier is that Cypress would remain open even if we did the west side of it. Cypress would remain open and it would still flow and operate just like it is. There would just be a curb on the west side.
Okay.
And the only thing, and if it gives heartburn, because that's such a future issue, we can always come back and go through the street vacation process again at such time we have someone like we have for the west side, if that's what's causing issue here.
So we
You know,
can
we can
talk
always-
about, we can just talk about West Cypress and Birch all the way to Crawford and leave the other part
Yeah,
for
the
later.
request was made in this fashion to avoid going through this whole process again on the east side.
Correct.
And the Planning Commission thought that it give it the opportunity to develop, and that's why it came from the Planning Commission in this fashion.
Okay.
If that's what's causing the heartburn here and the confusion here, we can always go through the whole process again, just like we did with the west side when we have a site plan and all of that. Then Cypress continues to flow, and we've got a curb on the.
Yeah, I think, I appreciate, I understand that. I think it's probably my lack of, what's that?
No, go ahead.
Okay, I think it's probably my lack of clarity though I can't tell a landowner what to do with their land. There's a tenant that exists on one side, and there is an unused piece of property that over time can deteriorate, become a nuisance, et cetera. So my focus of expanding our city and expanding our businesses and expanding our town isn't necessarily where there's a tenant that would be replaced or relocated or whatever, but is on the piece across the street that's being unused. I would not want to handicap that by not having the ability to close Cypress, but we have heard from an existing business that they don't want that right there. So, you know, if you strip the two of them apart, which I think is what I'm now hearing, if you strip the two of them apart, that makes completely different consideration. Then you're really just considering what's over on the property that we'd say is the west side property. And I was trying to make a livable solution by the two pieces of property tied together. One would not be developed without a plan on both.
So how do we proceed, since that isn't how,
And if we can't proceed based on that, then...
does it have to go back to Planning Commission to split it up? Or do we have the power to rephrase this? Anyone? Mr. Schrag?
Commissioner Jennings, you're...
Yeah, and I guess I'm uncomfortable with the ability to change it in second reading merely because we're sending a developer out there saying, you know, if we don't really address what's on my mind right now, or a possible commissioner's mind right now, then we send a developer out, there's a contract that moves forward, there's, Rods becomes evicted, and things move, and then we get to a second reading, and then we abruptly put on the brakes and say, wait, no, without you doing something over here, we really don't want you doing something over there. So I'm trying to be, and it might be only my position on the commission that has that, but I'm trying to be completely honest that is my thought process on these two pieces of property.
Can they do anything on the west side until second reading?
No.
So they wouldn't be able to move forward at the
No.
Rods location until we had the 2 site plans in place and passed second reading.
But what they're saying is the one site plan.
Right. Yeah, if I may try to address Mr. Bankston's question from a while ago, and I may be wading into swift water here. I think part of the question was, is it practical to expect a site plan on the east lot? And from what I've heard, until you have a tenant, it's not likely that we're going to have a final site plan for that property. You're going to site the building, the parking lot, the circulation. However, with the extension of Birch Street, there is somewhat of an interrelationship. I mean, it's not uncommon for us to restrict access on a particular street that it adjoins, especially in the instance that we're extending Birch Street. So in my mind, it's plausible to have some connection there. But if I understand what you're saying, it seems to me the question is, can we condition what you'd like to see in the interim is some development of the property in terms of removing what's there and grading it and making it more presentable. That's typically not a site plan that would be submitted to us in that form.
And I guess Commissioner Angel kind of touched upon it, or maybe it was the mayor. It came to us as this package. We might have the liberty to break it apart, but it was discussed upon. The issues that were brought up were these two pieces of property, possible uses on both pieces of property, access to the park and how it's affected with the two pieces of property, traffic flow through the neighborhood with the two pieces of property. And I imagine it'd be a completely different discussion if it was completely the west side property and the affected work to the surrounding roads.
Mayor and Commissioners, I hesitate, but it would be extremely helpful for me to have an opportunity to address a couple of legal issues in executive session with you related to this matter.
Right now.
If that's your wish. I mean, this consideration of the matter now or later is obviously at your discretion, but
How long of a...
I would think 10 minutes.
And this is attorney-client?
Yes.
Okay.
Mayor, I'd like to move we recess into executive session for 10 minutes to discuss with legal counsel matters subject to the attorney-client privilege for the reason of public discussion of those matters would waive the privilege and adversely affect the city's interest in the matters, and reconvene at this room at 6:30 p.m.
Second.
It's been moved and seconded that we recess into executive session for 10 minutes. All those in favor say aye.
Aye.
All those opposed say nay. Motion passes. We are in executive session until 6:30, and there will be action. After. The City Commission meeting. Mr. Bingston?
Cozy over here. Thank you, Mayor. Commissioners. Just wanted to briefly explain for folks that I mean, this is some new territory for us to have executive sessions in the context of this type of matter. And I just wanted to assure everybody that that is not for the opportunity for the commissioners to sort out their decision privately. It's the opportunity for me as their legal counsel to address some issues that I felt were coming up in terms of their options, the legality of various options, and that's the point of it, strictly legal matters. So I can assure you that nothing was decided, and I'm sure we'll prove that here in a minute. But I had the opportunity I needed, and I appreciate that. The only other thing that I might mention is a housekeeping item, and I'll look out of the corner of my eye to Mr. Mars to make sure I'm tracking okay with him. We've had a couple of motions floating around, and as a technical matter, if the discussion gets to a point where any of you choose to make a motion or think we're getting there, we may want to do so now or at whatever time would be appropriate. But given the deliberations and the actions that you've had to this point, it would probably be most appropriate if you get to a point in this conversation today where any of you wish to make a motion. I think we need to probably first address the matter of whether you wish to reconsider the matter. We've had enough motions flying that I'm concerned that we kind of clear the deck, and the way to do that would be simply a motion to reconsider the matter for today's purposes.
Do I need to remove the motion? Do we need to, do I need to call the question so it can die, or do we just ask for reconsideration?
Did we leave with a motion on the table?
Yes.
Okay, we did. So does he have to remove it?
Which?
That's up to,
or do we?
That's up to Commissioner Jennings. That's certainly one way to address the matter as far as his motion is concerned.
Okay. Then at this time, Mayor, I would ask to withdraw the motion that's currently on the table.
Do we vote on that, or does it just happen?
That simply happens. I can't recall if there was a second by the time.
No. Or was there a second?
Did I second it?
At which time? Yeah. Okay. So since there was a motion and a second, what do we need to do then to take that off?
Well, I think with concurrence by the person
Yeah,
making the motion and the second.
It says if the maker of the motion withdraws the motion, the entire motion dies.
Okay.
Very good.
Okay. So now,
We need to
part
move.
two. Okay. Commissioner Angel or Commissioner Jennings, were one of you prepared to make a motion?
Do we need to move to reconsider?
Yes.
Let's clear the deck if you wouldn't mind.
I move that we can reconsider the issue of ordinance number 09-10525.
Second.
It's been moved and seconded to reconsider ordinance number 09-10525 as presented. All those in favor say aye.
Aye.
All those opposed say nay.
Nay.
Motion carries 3-1 with Arpke. It's been a long night. Arpke dissenting.
Been there.
Well, I just want to ensure that I understand where Commissioner Jennings is coming from, so we can, I guess, discuss the matter further. And it's my understanding his intent is to make sure there's some kind of mutual agreement in place with regard to the east and west lot to make sure that, I guess, the agreement is mutual so that either development or at least some cleanup happens on both lots instead of having development on one and having the other lot in limbo.
That's correct.
So, does anyone else have any discussion before I make a motion?
But I think your concern was that the extension of Birch all the way to Crawford was never a question. It's the tying of the two sides of Cypress into this first reading.
Yeah, once we extend Birch, it kind of separated, but kept, it's a single petition. And for me, I'm looking at both sides of the street, as Commissioner Angel said, as one. So I believe we would have to look towards staff at the at the development of a development agreement that would be another condition of the second reading to be in place in order for there to be any approval of second reading. Then that development agreement would have to be entered in upon second reading that would address both pieces of property.
And we want to leave these tied together. I understand by Mr. Andrews' comment that the reason Planning Commission wanted this as one item is so that when the east side developed, they would not have to start all over and go through this process. Is that correct? Am I correct to understand all of this? That is why the Planning Commission did not want to do it into two pieces.
They understood that if the west side of Cypress or West Leg was looked at only, that if there was a petition to move forward with vacation of the east side separate, then the whole process would start over.
Okay,
as opposed to being dealt with as one issue.
So we're going to keep them tied together as long as all the conditions are met. Is that correct? Okay.
So I move that we adopt on first reading ordinance 09-10525 with the conditions adopted by the Planning Commission on January 5th, 2010, and with a seventh condition that a mutual development agreement be in place prior to second reading that addresses development, cleaning up, or some type of clearing of both lots owned by, what's her name? Mrs. Kaufman.
Commissioner, would just want to clarify for your motion on the what would happen on the lot on the east of Birch. Would the clearing in essence include removal of existing structures, foundations, floor slabs, basically anything that would make the lot look other than a seated lot?
I think the intent was it's going to be now it's going to be a lot fronting what will be Birch all the way through to Crawford. So the intent would be to clear it, grade it, seed it so that it's presentable and fronts that street when it fronts that street.
And I need to make sure that I understand the Cypress section on the east side. Then upon second reading would be closed.
If the development agreements are in place and approved by the commission.
By second reading.
Second reading.
Okay. The motion was on the floor. Was there a second?
Second.
It's been moved and seconded to adopt on first reading ordinance number 09-10525 as presented by the Planning Commission at their January 5th, 2010 meeting, with adding the seventh condition as presented. All those in favor say aye. Aye. All those opposed say nay.
Nay.
Motion passes 3-1 with ARPG dissenting. It is 5 till 7. We are going to take a 5-minute recess so that we can proceed with the consent agenda. Do I need a motion for a recess?
No.
No? We will recess for 5 minutes and reconvene at 7 o'clock. All right, we're continuing. Thank you, everyone, for that short recess. We will now proceed with the consent agenda.
Item 6.1, approve the minutes of January 11, 2010. Item 6.2, acceptance of public drainage easement dedication in Block 9 of the Key Acres Edition. Item 6.3, acknowledge receipt of a special law enforcement trust fund report.
Does the commissioner wish to pull anything from the consent agenda? If not, I'll ask for action.
Mayor, I move we approve the consent agenda.
Second?
It's been moved and seconded to approve the consent agenda. All those in favor say aye.
Aye.
All those opposed say nay. Motion passes 4-0. Development business?
Item 7.1, resolution number 10-6700, adopting the Community Improvement District policy.
Mr. Gage.
Thank you, Mayor and Commissioners. We'll try to get through this as quickly as I can for you. In 2009, the state legislature approved the Community Improvement District Act, and it allows cities and counties to create community improvement districts. What a CID, we'll call that a CID, and what a CID does is provide for the financing of projects located within a district boundary, included but not limited to site improvements, infrastructure, building, parking facilities, parks, transit facilities, maintenance, security, marketing, training, and there's some other things as well, through an increase in the sales tax for the CID with special assessments and or the issuance of bonds. In 2009, you considered an application for Sunset Plaza on West Crawford. At that time, the application was not approved, and you asked the staff to go back and look at a policy, in essence, for utilizing the CID Act that the state had approved. So that's what we have in front of you today. Basically, I'll give you a little bit more detail what the Act provides for. Its CIDs are formed upon a petition from an applicant. It has to be, there's a couple of ways that can happen. One is signed by 100% of the property owners within a district if funding is only from special assessments and without general obligation bonds. Some strange combinations, which is why you have a matrix on the back of this. So special assessments, no general obligation bonds, takes 100% of the property owners. 55% of the property owners by land area, at least that, and more than 55% of the assessed value, so you have two 55% aspects there. Within the CID, if funding is only from sales tax or from sales taxes with other funding sources. So you have, this, in essence, a special assessment CID and the sales tax CID. The sales tax CID can utilize bonds, special obligation bonds, general obligation bonds. It's pretty wide open. A special assessment only CID may be created without notice or hearing upon adoption of a resolution, though we do recommend a public hearing because we believe that it provides an opportunity to, once the owner's notified tenants, for those tenants to have a place to be heard. So we think that it made sense to go ahead and include that public hearing even though it's not required. For other forms of a CID, the governing body must adopt a resolution calling a public hearing on the advisability. We mentioned that. And then the governing body may create the CID and authorize a project. Again, we talked about the funding being from special assessments or sales tax up to 2%. In addition to the existing overlapping levy, the overlapping is all taxing entities, in increments of 0.1% or 0.25%, so in tenths of a percent or quarters of a percent for up to 22 years. And then the city has the ability to appropriate other funds if you would choose to ever do that. Special assessments have to be levied in accordance with the special assessment law, which is KSA 12-6A01 and the remaining sections of that. As I mentioned, a city may issue either special obligation bonds or general obligation bonds to fund CID improvements. I've kind of outlined here for you the purpose of a CID, and the purpose, the proposed policy. The policy provides a purpose statement. We feel there is a purpose in this, and it really has two main emphasis. It's set up to where you could allow a CID to be formed anywhere throughout the community. It does emphasize the area known as a special, or what do we call it, yes, well, it's a special redevelopment area, but areas of change. That's a term that's come up in the draft comprehensive plan. It's a pretty large section of the north part of town and the west part of town. And basically, we're saying this is a pretty good tool for redevelopment opportunities in those somewhat declining neighborhoods and areas. But nothing here in any way prohibits the use of the tool anywhere else in the community. You could use it for green space if you choose to do that. It does provide some, the policy provides some general guidance to the commission, but I want to emphasize that the governing body in the policy has discretion to waive the provisions of the policy for any compelling reasons you would like or emergencies. We do that because, one, it doesn't make sense to put you in a corner for the most part, because every application will be different and have its own nuances that you need to deal with. So we recognize that in creating a policy. A list of the eligible construction, building infrastructure, and service costs per state statute are included. You could, if you wish to, just carve some of those out and say there are certain costs that under no circumstance would we want to fund. You could do that, or you could simply leave that discretion to yourselves at the time you get an application. What we did is simply replicate those eligible costs in accordance with state statute. There's a general limitation regarding the inclusion of service costs not to exceed 15% of the total project, and provision to demonstrate how those costs will enhance the business activity. So if you felt that you wanted to allow certain service costs, security, marketing, things like that, the policy certainly says you can do that, but as a policy guideline, we've said that should be limited to 15%, primarily with the thought that the emphasis should be on physical development and redevelopment of the property. We provide an overview of the financing methods, the bonding methods, or pay-as-you-go. Certainly, I think there should always be first consideration of a pay-as-you-go, because once you get into bonding, you get into much further analysis and deeper analysis. And depending on the type of bonds that are used, if they're GO bonds, you would put the city's credit on the line, and you want to be pretty sure that you're going to have a successful project. So certainly, pay-as-you-go makes more sense when it's available. We include in here the application petition procedure. That's included. I won't get into the details of that. We have a guideline that the applicant should provide on their own at least 25% of the total project cost. In other words, they have to have some skin in the game rather than leverage 100%. Again, if you'd like to modify that number, you could. And when we did this, we recognized there's certain preferences that each of you had, and it's really kind of hard to try to put all those together. We included all applicable fees, which the total of these cannot exceed 5% with regards to reimbursement. And that's something that we would communicate to an applicant before they officially apply. But there are three primary fees. One is a non-refundable application fee of $2,500. There's some talk in the study session of changing that. We left it and thought that you could talk about that here. The thing is you'll have smaller projects and larger projects, so it may just depend on the project, but we felt that a simple flat fee is pretty easy to understand and administer. There's a fee that deals with reimbursement provision for out-of-pocket professional service fees. We think particularly that would be applied with bonding. It's possible it might in other projects, but if we were going to bond a project and put our credit on the line, we would want to do some analysis in the same way we did with the tax increment finance district that included the Kohl's store. So if that analysis would include third-party professional consultant fees, bond counsel, marketing consultants, and so forth, or market consultants. And so we would want to make sure that the city didn't have to pay for that we were reimbursed for those costs. And an ongoing administration fee of not to exceed 2% of the project. That is to cover costs that we will have annually with regards to administering the project. The money's coming in and the distribution back to the developer in accordance with the contract. That will run through finance and could possibly have some legal costs associated with that, and we felt it made sense to recover that. So the three sets of fees are outlined. Probably the crux of this is the criteria that we kind of laid out there, and there's a lot of criteria. One is compliance with the comprehensive plan and all land use regulations. Our thought being is if there's a land use decision, get it out of the way before the CID petition comes in front of you, because you start to get yourself a bit compromised if you do the funding first. The status of the CID is an area of change or declining commercial property, so it doesn't have to be in the area of change. The degree of aesthetic, structural, functional, and economic need of the CID, so there's a lot of aspects to that. Ability of the project to improve the aesthetic and economic outcomes and to resist future decline of the district. And I think the big part is to resist future decline. I think that's real important. It's a long-term decision. The overall neighborhood impact, proportion of private financing contributed. You might say, well, the minimum's 25, but if they want to contribute 50%, that might be a factor you consider. The fairness of the proposed funding plan allocation between sales tax generators and non-sales tax generators. I'll tell you that in our discussions, almost any way we looked at it, if you have that mixed group, it gets really, really difficult on your options. And so it's possible you may never have that mixed group. I don't know. But if you do, our thought is we should try to make sure that the funding source or the funding is actually allocated as fairly and equitably as possible wherever we can do that. And that's the intent of that. We think you need to look at the financial risk of default and the financial risk to the city, including the exposure of the general property tax levy and the city's credit rating. Certainly, if you have a pay-as-you-go situation, you really don't have that type of exposure. If you get into bonding, you do. The feasibility of future CID revenues to cover the ongoing viability of the project, particularly when financing includes bonds. So, you know, if we have financial estimates of the revenue coming in, do we really think the project will produce? And you'll get that in. If you issue bonds and the project doesn't produce, then that means the taxpayers at large end up paying for that project because we have to make the bond payment. So we want to look at that and make sure. Again, that's pretty similar as with regards to what we did with the TIF. The site layout and architectural design. And then here's one, the degree to which the project enhances all aspects of the building space. This was discussed before. The interior, which is really something that's emerged in discussions when we looked at the total impact to a tenant, the exterior, the mechanical, electrical systems, et cetera, that affect the actual functionality and tenant demand. So we took a much broader perspective of that, and I hope we nailed that one for you. The use of landscaping and other sustainable features with an emphasis on xeriscaping, the low water type stuff. We think that makes sense. The impact on city infrastructure systems and optional off-site infrastructure improvements. We may have some infrastructure needs that are near the project and it probably complement the project, but not necessarily within the district. Could be median upgrades or something such as that. The extent to which the project will help the CID attract new customers from outside Salina with a particular emphasis, you can eliminate the particular emphasis on new development. That was actually stricken because we said it really both new and existing are equal. So really the primary thing is the ability to attract new customers from outside of Salina, and also the extent to which the project will help the CID retain customers in Salina who may currently be leaving the community. These are our two main factors that we have in the new Salina Area Economic Development Strategic Plan, so we felt it made sense to have those in here as well. And the impact on customers, particularly captive customers. That was a discussion with the Sunset Plaza. I'm not sure we have great answers for that, but we said let's always look at it. I think that's the key thing, and every project, again, is a little bit different. The other thing we added in here is a requirement that the applicant make its best efforts to mail to tenants located within the proposed CID the public hearing notice at least 10 days prior to the hearing date. We felt that in the last process it was important for you to hear from the tenants, and it's better to formalize that if we can so that you all get the same information at the same time and you can digest that. And that's one reason we did include a public hearing for the special assessment only. The reason the statute didn't is because 100% of the owners sign it, but the statute didn't take in consideration tenants. So we wanted to do that. Utilization of a development agreement to ensure all project elements are completed as proposed and agreed upon. So not only would you be running the, having the petition and in essence maybe possibly approving a petition, and the petition has a lot of detail, but we would have an accompanying development agreement that would outline the timelines. If there are certain timelines and performance aspects that we want to make sure we nail down, we would have that in a development agreement so that no one gets lost along the way. Again, I don't know that the policy we have can address all individual concerns or all the project nuances. I think that's almost impossible, but I think what we've tried to do here is lay out a solid framework that you can use to consider an application, and it allows you with some flexibility. These are guidelines, again, and so you have the flexibility if you have a situation in which you think you want to amend it. An example might be is maybe we do have a group application request, and maybe it's a downtown group and it's for marketing, and you say you think that's a good need and they're all in agreement. Okay, if that happens, you want to be able to address that. Well, that's something that's not probably a typical application, and so you say, well, there's that 15% maximum of service costs in the plan, but you could say, well, that's so much different that we're okay, allowing that number to change. So that's an example of a situation in which you might want to do more on those service costs versus the hard costs. We do believe that it does meet complies with the strategic plan. The goal, number one, that the city will create a community of mixed-use quality development and redevelopment. We just think it gives you a framework to hopefully stimulate development in areas that you'd like to do that. Whether, again, it's just green space that's been undeveloped for years and you really think there's potential for the community, or whether it's a rundown commercial development that you think needs some energy inside and out, and that you believe will actually help that neighborhood and that development in the community. There's obviously no fiscal impact of this item at this time. So we give you three options, as we typically do on most of these, is to adopt a resolution, proposing community improvement district policy as it's written. That's resolution 10-6700. approve the resolution as you might want to amend it if there's certain aspects you'd like to amend, or not to approve the resolution at this time if you're not comfortable doing that. So with that, if you have any questions, we will try to tackle them the best we can.
Up above where you were reading, the extent to which the project will help the CID attract new customers from outside Salina, you said you wanted to strike that with a particular emphasis on new development because it's new, or?
Yeah, initially we had that in our draft, and I think it got in there by accident. We all looked at it and said, well, that wasn't really our intent, so.
Because it's existing.
Yeah, it's not in the policy, it just was
Okay.
accidentally left in the blue sheet.
Okay. Okay. Any questions of Mr. Gage? Thank you. I'll open it up to public comment.
Dennis Lauber from the Salina Area Chamber of Commerce. Thank you, Mayor and members of the Commission. At one point in the process, I said to several people, in hindsight, it would have been probably better if back on July 1st, which was the first day, 2009, that this was law, 13 hours after this became law, if we had said to the Sunset Plaza folks, wait, let us get a policy put together, then come back, then all would have been better. On the other hand, I'm not sure that if we had done that, what you would have in front of you today is a policy that is as sound and well-written and thought out as the policy that's before you, because that process we went through brought to mind various aspects associated with that. So I think what you've got before you is a very sound piece of public policy. And I thank you for your input and study session, and staff and everybody for their work to this point.
Thank you, Mr. Lauber. Any other comments? If not, I'll bring it back to the Commission for action.
Mayor, I move we adopt resolution number 10-6700.
Second.
It's been moved and seconded to adopt resolution number 10-6700, adopting the Community Improvement District Policy. All those in favor say aye.
Aye.
All those opposed say nay. Motion passes 4-0. Administration.
Item 8.1, authorization to submit the Municipal Water Conservation Plan as revised January 2010 to the Kansas Water Office and the Division of Water Resources for approval.
Ms. Tasker.
Thank you, Mayor and Commissioners. I'm going to try to follow Jason's lead and move through this as quickly as possible. On November 12th of 2009, City staff and HDR conducted a public meeting to explain the revisions of the Municipal Water Conservation Plan, and particularly in respect to private domestic wells. Then we followed up with a study session on November 23rd, where City staff and HDR presented the comments from the public meeting and the revisions to the Municipal Water Conservation Plan. In 2007, the Kansas Water Office published the 2007 Municipal Conservation Plan Guidelines, which updated the 1990 guidelines. The relevant change at that time is that private domestic wells may be included in the drought response if that's approved by the Chief Engineer of the Division of Water Resources. The 2010 plan incorporates the 2007 Municipal Water Conservation Guidelines with concerns and issues that were brought to staff's notice when we were dealing with the 2006 water emergency. There are basically three main concerns or revisions to the plan, with the first being water use efficiency. The 1997 plan included a water conservation goal not to exceed of 140 gallons per capita per day, or gallons per person. And the 2010 plan goal is 116 gallons per day per capita. For reference, in 2007, the city utilized 116 gallons per day per capita, and then in 2008 and 2009, approximately 110 gallons per day per capita. The second revision is regulation of private domestic wells. The 2010 plan, if approved by DWR, would allow the city to restrict water use from private domestic wells when either two separate specific conditions occur, with the first being when the city is experiencing a period of drought and we're in a watch, warning, or emergency, and the second when waste of water is occurring. In general, the private domestic well owners would fall under the same regulations that the customers connected to the water distribution system comply with. In the times of a watch, warning, or an emergency, they would follow the same restrictions. And secondly, when the waste of water regulation applies, which prohibits outdoor watering between 10 a.m. and 6 p.m. between June 1st and September 30th would apply. The third is revisions to the drought emergency response trigger points with respect to the river and groundwater conditions of supplies. Conditions were added to include winter and summer flow rates for the river. And second, we added provisions for a declining trend to avoid triggering in and out of a watch, warning, and emergency based on the quick changes of the river flows. And third, a specific depth of water at the Oakdale monitoring well was included, which is intended to protect our wells and our well equipment. In addition, the 2010 plan addresses how to terminate each of the stages. Over the past 40 years, if we were complying with this municipal water conservation plan under the 1997 plan, approximately 15% of the days would have fallen in either a watch, warning, or an emergency. With the proposed 2010 plan, approximately 10% of the days. There is no physical impact to the 2010 budget. For the years 2011 and on, its estimated requirements are $3,000 for outreach and education and $17,000 for rebate programs. Staff has identified two options for consideration, with the first being authorized staff to submit the municipal water conservation plan for the City of Salina as revised January 2010 to the Kansas Water Office and the Division of Water Resources for approval, or the second option, instruct staff regarding amending the municipal water conservation plan. At this time, I would be glad to answer any questions you might have.
Ms. Tasker, my question is on the wells, on the not the regulating, but of the, well, I guess regulating of the wells. Did you say that they do not have to follow our June, September?
They do have to follow those same regulations under the waste of water regulation that we currently have in place. They would follow those same.
We have no way still, though, or we're not implementing any way of knowing how many wells we have because they don't have to be recorded. Is that correct?
The wells are recorded if they were drilled by a professional well driller from about 1975 on. Those prior to that are not recorded, and some wells were drilled by hand or by private individuals, so we don't have an exact count. We know that there's at least 1,500 to 2,000 that are registered, and we're estimating in Salina.
Okay.
And we're estimating that we're probably somewhere in the range of 2,500 to 3,000, but that's just our best guess.
And of those people, only 30 attended this meeting?
Yes, 30 attended the public meeting.
Anybody call you outside the meeting and just voice their concern or send you an email? And
I would say I had as many that were positive for this, that were city customers that were glad to see well owners fall under the same regulations as I did to the negative side. So
okay. Because as a past mayor once said, it all comes from the same bathtub. So even though they have a private well, I'm glad that they're realizing it, that we have to be respectful of water in general. So, okay, that's all I had. Other questions of Ms. Tasker?
During the drought time, how close were we to running out of water?
In general, we were at a point to where there was approximately a little over, I think it was 1.7 cubic feet per second in the river, which is, if you think about a cubic feet is 7.48 gallons. We were pretty low flow then. And we asked the Division of Water Resources to administer our water rights, which brought flow back to the river.
Okay, good. And then just clarifying, under the new plan, the percent of time when we would actually be in watch or emergency is a lower percentage of time.
That is correct.
Okay. So it's not more restrictive on the surface than with that. And then the only other clarification I had was on the outdoor watering. Is it just in general, and this is just a question for clarification, is it just in general at any time, June 1 through September 30th, that there's no watering 10 a.m. to 6 p.m., or is it only during certain conditions?
No, that is in place that entire time frame, and particularly outdoor watering being irrigation. Hand watering of flowers and plants is allowed during that time.
Okay.
Can
Thank
you
you.
remind me on, are you done? Okay. On how that applies to food gardens?
Typically with the gardens, they're hand watering a large portion of the time.
Okay.
And
How about for the community gardens? That's quite a large area.
Really have not had that question come up, but I would assume they would want to water during an efficient time also, before 10 or after 6, if they're using overhead or above ground irrigation, because the evaporation would be great at that time for them also.
What about washing of cars and boats and things?
There is no issues that pertain to that unless we fall into the water warning.
Okay.
In a water watch, it's voluntary, but when we move into a water warning, then washing of cars was, in 2006 and 7, was restricted to 1 day per week.
So in the 2010 plan, that's not considered wasteful if you're washing your car, if you're washing your car at,
Not
2
under
o'clock in the afternoon?
Not
That's
under the
considered?
current plan.
Okay.
It's put together unless we're in a
drought or a warning?
drought condition of some
warning.
type.
Okay.
Yes.
Additional questions? Thank you. Any public comment?
Larry Carter, 2945 Tasker Lane. Thanks for listening, Mayor and Commissioners. I attended the informative meeting that we had earlier in November discussing the water of the private wells. Just the private well section is the only part I'm really not happy with. And we actually talked about the amount of wastewater we're talking about with irrigating your lawn. And it came down to a figure of a low as 5% with well efficiency sprinklers, up to 10% if you're doing it with incorrect ways of irrigating, because the rest of the water actually goes back down to the aquifer. And it was all agreed that it's a minuscule, almost not anything to do with the kind of figures they're looking for. They're looking for lots of water waste. So it doesn't really affect much by stopping the private wells. We're talking about a very minute, like flushing your toilet twice amount of water, which is not affecting much. So the private well, when I put it in, I made my decisions thinking I had water I could use to either keep my lawn green, plants, garden, and by taking it away, you're also affecting the property value, I feel, of the house. And the word private well, that's exactly what it means to me. It should be a private well we put in. Changing it in the future from now wells that are put in would not disturb me, but I would think we ought to be grandfathered our private wells because we made the decisions on the way we could use them then. That's all I'd say. Thank you.
Thank you, sir, and thank you for being patient all night long to voice your opinion on that. Any other public comment?
Hi, I'm JT Davis, and I live at 332 North Oakdale, and I'm going to try making this nice and brief. I made an investment on my well to be drilled. I do not use a lot of water on my yard. It's not that big. If you guys want, you could put a meter on it, and you could just see how it is for the year. Water wells on the hill have nothing to do with the aquifer. There has to be a few up there. There's a lot of houses up there. I've seen a few of them, like along Crawford by Marymount and stuff like that. They water, and the water has to go someplace. Hand watering and drip systems are 90 to 95% efficient and should be exempt. For gardens and trees at least, or have people start putting high efficient sprinkler heads in, it replaces most of the water used back to the aquifer. Make an ordinance to have people install high efficient watering systems. The ban would not help when millions of gallons of water just flow in by the channel that the city has rights to, and we are not saving any of it. Should use the water to make like a fishing area, help make a backup water source. The Friends of the River should help with this part when they get more water flowing through the river through Salina. You're going to have an added cost of having a water cop to enforce the ban. People that live and have the river next to their houses just could drop a pump into the river and water their yards. They ain't touching the aquifer, and the water's going to be going down the river anyway. So there's no other ban like this in the whole state of Kansas. Like western Kansas, there is none. So that's all I got to say. Thank you.
Thank you, sir. I don't think we have a water ban. I mean, I think it's just a...
Just a clarification, for a private well, Commissioner Harpke asked about like vegetable gardens and so on, and that's hand watered, and that's okay. Is that the same on a private well? They'd be able to hand water?
That would be true, and the drip irrigations are very efficient, and we're basically after waste of water that's evaporated into the air. That's
or
what we
going
consider.
down the street,
Or running down the street, excess watering, that type of thing.
Okay, that's what I thought.
Martha, when you talk about drip irrigation, soaker hoses would be included in that as well?
Yes.
Is okay?
That's basically efficient.
All right, thank you for clarification.
Martha, I just want to confirm that the policies in here apply to the governmental agencies within City of Salina as well as private individuals.
Yes, they do.
Okay.
Occasionally, staff will make a mistake and test a system or do something, and usually we find out about that very quickly and correct it.
Yeah.
Thank you.
You have some loyal citizens that make sure that let you know.
Eagle eyes.
Exactly. Any other public comment? If not, I'll bring it back to the commission for action.
Mayor, I move that we authorize the staff to submit the municipal water conservation plan for the city of Salina as revised January 2010 to the Kansas Water Office and the Division of Water Resources for approval.
Second.
It's been moved and seconded for authorization to submit the municipal water conservation plan as revised January 2010 to the Kansas Water Office and the Division of Water Resources for approval. All those in favor say aye.
Aye.
All those opposed say nay. Motion passes 4-0.
Item 8.2, certification of final costs for the 2009 special assessment projects and setting the date of public hearing. Sub-item 8.2A, first reading ordinance number 10-10,531, levying special assessments for improvements.
Last but not least, Mr. Stack.
Thank you, Mayor and Commissioners. This is an annual initiation for basically the hearing and establishing the calendar for our general obligation bonds sales for the year, basically, and it's a calendar that starts now with the final cost being determined by engineering of the two projects we had last year, which were Stone Creek and Schooler, and then this actually initiates the hearing date, and the notices will be mailed and published, and then over the course of about 4 months, the closing and delivery of funds on the 29th of April is the approximate date. So I guess any questions on that?
29th of April or April 19th? What did you say?
April 19th. Let's see. I have a new, making sure I got this right.
Yeah, I just think you said the wrong date. March
I did.
29th. Yeah, the timeline is right here. Is that correct? March 29th?
Yes.
the first reading of the bond ordinance, and then April 19th with the second reading?
Mm-hmm.
Okay. Any questions of Mr. Stack?
Yeah, I've got an old calendar. This one's not right.
No questions? Okay, thank you. I'll open it up to public comment. Seeing that there is none, I'll bring it back to the commission for action.
Mayor, I move we set February 22nd, 2010 as a special assessment hearing date and pass ordinance number 10-10531 on first reading.
Second.
It's been moved and seconded on first reading to pass ordinance number 10-10531, levying special assessments for improvements. All those in favor say aye.
Aye.
All those opposed say nay. Motion passes 4-0.
Mayor, I move that we recess into executive session for 20 minutes to discuss with legal counsel matters subject to attorney-client privilege for the reason that public discussion of those matters would waive the privilege and adversely affect the city's interests in the matters, and reconvene the room at 7:55.
Second.
Thank you.
Were you going to say something? Okay. It's been moved and seconded that we recess into executive session. All those in favor say aye.
Aye.
All those opposed say nay. Do you expect any action?
We do not.
We are in executive session.